So, good afternoon. My name is Jim Corbett, and I'm going to give a quick presentation on Casemaker. And I just came in the other day from Seattle, where I work out of my home office there, and happy to be here. So, can I just do a quick survey of the room and find out how many people are familiar with Casemaker or have used Casemaker? Okay, so about half the room. Okay, great. So just okay. Thanks. Okay, is that better? Okay. So Casemaker is a legal research service. Our business model is to work with bar associations to provide the service as a member benefit. We've worked with the Nebraska Bar for close to 15 years, providing this service as a member benefit. And we have contracts like the one with Nebraska with 22 state bars and a variety of county and city bars around the country. So it's a very frequently used service. We have about 300,000 attorneys a month who are signing in and using Casemaker for their legal research. And most of them are using it as their principal or primary source of legal research. And it's a very well-regarded member benefit here in the Nebraska Bar. So what I'll do today, because I only have about a half an hour, so I'm going to take you on just a quick tour of some of the features and functionality of the service so that you will be able to compare it to whatever other service you might be using. You might be using Lexis or Westlaw for your legal research, and when you see the comparison of the services, you might consider using Casemaker as your tool. Remember, as we go through this is a free member benefit to you, and a lot of people who use the service have dropped their Lexis or Westlaw subscriptions, because if you are relying mostly on the primary sources, that is the cases, codes, rules, regs, those kind of things, if that's the primary focus of your research, then Casemaker, I think you'll find, has exactly the same material that Westlaw and Lexis have. And if you rely on, say, a Westlaw contract because there are certain secondary sources that you get from them that you just can't live without, some authored publications or treatises that they provide that you can only get through a contract with them, then you really do need to keep your Westlaw contract. But most people in small firms or solos, which is what I'm led to believe is what represented here, most of them have the most basic Lexis or Westlaw contract, which includes only the cases, codes, rules, and regs. So I think you'll see that we have a very competitive service in that regard, and I hope you'll consider using it. And are you all members of the bar? Is that why you're here? Presumably because you are members of the Nebraska Bar. So this is something that is free as a member benefit. And so even if you are only considering using Casemaker, you can use it in conjunction with your Westlaw contract starting right now. You don't even have to sign up for anything. You just go in through the Nebraska Bar website, click on the Casemaker logo, and you will end up on this screen right behind me here. Okay, and from there you'll see that we have the state cases. That's the default display that comes up on the screen. You'll see that we also have the federal material here. This is all available to you. Sometimes when you are getting your most basic Lexis or Westlaw contract, you're only getting your own state and your own federal materials. With the Casemaker contract through the bar, you're getting all 50 states and all federal materials. And we also have a citator, which will be the equivalent of KeyCite or Shepard's. That's included within the service. And we have a few other things that are available as well, and I can quickly show you those under the Features tab here. The most notable ones to think about are the Casemaker Digest and a service we have called Site Check. The Casemaker Digest is an updating or an alert service that will allow you to set up searches in categories or areas of law that will, you can set up a search so that it will show you on either a daily or weekly basis, whatever you choose, and send you the most recent cases in that area of law. So let's say you're a family law practitioner or an environmental law practitioner. We have 57 different areas of law for you to choose from. And, so you set those up, and on a daily or weekly basis, it will then send you the most recent cases in that area. And so it's a great way for you to keep up to date with what's going on in your chosen area of practice. There's no limit to the number of those you could set up. So if you wanted to set up more than one, you can do that. There's no limit on the time frame for which you can leave those, active, and they are free. Okay, it's part of the service. The Site Check service is a service that allows you to upload a brief or any other legal document that has citations in it. Casemaker will parse through the document, find the legal citations, run them through our citator, and tell you kind of yay or nay on whether that case is good law. So there's two great times when you would want to consider using that service. One is when you have written a brief and you're about to hand it into the court, and as a last-minute check to make sure that nothing has changed since the last time you checked these sites, you want to make sure that everything's good, you run it through and you get your stamp of approval. The other time is when you have a brief that you have received from opposing counsel and you want to run their brief through here. All right, we simply take that brief, run it through, check the sites, and that way, before you even read the document, you can find out if there are any sites in there that have been, that have been challenged in some way. So it's a very, very valuable service, and it's free. Okay, this is part of what you get with the Nebraska Bar program. Okay, all right. So. Let's see here. By the way, all of the things that I'm going to show you today are also available to you not only through your computer or in your office or laptop, wherever you are, but also available to you through our mobile app. So that means if you're on the phone, you can use this on your phone or your tablet or any other mobile device that you have that you want to access it on. So, okay, so pretty handy. So in Nebraska, I'll just start out there. I'll just give you a quick look at the collection of material that we have. If I scroll down here, you'll see as a basic core of material in all 50 states, we have the cases, codes, rules, regs, session laws, admin decisions, etc., admin rules, I should say, and so that is at the basic level for every state. But in addition to that, in the states where we have contracts, like in Nebraska, we've added a lot more material and enhanced the collection. And largely we do that based on suggestions and requests from members of those bars, right? So if there is some agency material or some other kind of thing that you think would be very valuable to your practice and you would like to see that available on Casemaker, all you need to do is contact the people at the bar, Sam, for instance, and tell them, hey, here's this agency material, the decisions from this agency, here's the website where they can be found. He'll forward that to us, and we can get them online. Typically, we get them online in about 2 weeks. And then they'd be available to you and everybody else that uses the service. And so that's how databases like this grow. And so you'll see as I scroll down below the fold there, you'll see quite a few other items, okay? And and let me just tell you also that like Lexis, Westlaw, and other services out there, our cases are kept very, very current. We have our case coverage goes back to volume 1, the beginning of reported coverage in all 50 states. and in all federal jurisdictions, okay? So volume 1 of the U.S. reports, volume 1 of the Federal Reporter, et cetera, volume 1 of Nebraska reports, and so on, and kept current through yesterday. So that means that any cases that were reported by a court yesterday are online today. So very, very current. The codes that are provided by Casemaker are the most current versions of the codes anywhere. We have a staff of statute editors back in our headquarters in Charlottesville, Virginia, and they do nothing but track legislation in all 50 states and the U.S. Congress, and as bills are passed and enacted, they get them online within 4 days. And Lexis and West generally get them online within about 2 weeks. So this is the most current version of the code that you will find anywhere. And so it's a very accurate, reliable, and comprehensive service, okay? All right. So there's a couple of different ways that you can do searching on Casemaker. If you already know the citation of a document and you simply want to call that document up, whether it's a case, a code section, an AG opinion, anything like that, you can either just go in and type in the citation, or you can also just drill down through the hierarchy and get a copy of that document. Okay, so if you wanted to go into, let's say, Washington, where I am from, you go in. Let's say you want to pick up a Washington case. You have a Pacific Third site, and you just want to see the full text of that case. Here's the volume numbers. You just click on whatever the range of volume numbers is, and let's say we want to go into this volume right here, and we'll just pick a case here. And there is the full text of that case, okay? Once you have a case displayed, you can print it, email it, you can save it to a folder, or you can save it to a disk on your own computer and then manage it that way. You'll see that we have 2 sets of page numbers that track all the way through the document. Sometimes they're depending on who's publishing this, there may only be 1 set of page numbers, but where there are 2, we'll have both sets. And that way, if you are going through a document and you want to cite to a specific page number, you can do that, okay? So actually, we have a brand new feature. I'll see if this will work here. Yeah, so copy with citation, you can... So if you wanted to cut and paste a piece of this out of the document, put it into a brief that you're writing or something like that, you can copy it with a citation, so that'll be helpful, okay? All right. Saving things to folders, I'll talk about that in a few minutes, but let me go back to the home page here. So everybody see what I did in terms of just drilling down. I picked the jurisdiction, I picked the category of materials I wanted. The same thing works for if I wanted a code section from the California code that I don't have easy access to. I can just go in here, click, 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 drill down through that code section and pull up that title and section of the code, okay? Let's see. So that is, like I said, one way that you can quickly do a search when you already know the citation. Most times people are doing searches in multiple jurisdictions, right? And so what you do on Casemaker is, you see it's pretty easy. Here's where you type in your search, but here's where you would choose what your jurisdictions are. You just drop down that little menu there. You can search in all 50 states at once. You could search in all federal materials at once. You can see the list of jurisdictions. If you only wanted to search in the Supreme Court or the circuit courts, you can do, it's very flexible. You can choose any combination of jurisdictions that you want. Very simple, all right? So I have, because of some work that we've been doing here in presentations around Nebraska, I have pre-selected Iowa, Kansas, and Nebraska as my libraries, and we'll just go ahead and do that, okay? So, so let's say I type in wrongful termination, and what you see is I've typed in is everybody familiar with the Boolean operators associated with online legal research? A lot of people rely these days on the natural language search capabilities that Lexis and Westlaw provide, but I highly recommend that you consider using these Boolean operators. It's a much more powerful way to search, and even if you look at the Lexis and Westlaw user manuals, as they describe their own natural language search capabilities, they will recommend that you do it this way. They put it in there as a convenience, the natural language as a convenience, but this is really a more powerful way to do the legal research. Yes, sir. Yep. If you look right underneath, here's the search button up here, right? Right underneath there's thing that says search tips, and if you click on that, it will give you a list of those Boolean operators, and you'll be able to, like I said, you could print them out if you wanted to, or or refer to them at any point. And speaking of that, let me just quickly, since I only have a few minutes here, let me point out a couple of things that will be very useful to you. One is there is a list of videos. If you look across the top of the screen here, there's a number of like YouTube type videos that will describe various aspects of the service. And if you wanted to go in and do certain of these kind of things, learn more about our citator, learn about how to use folders, learn about the Casemaker digest that I mentioned earlier, any of those kind of things. There's a video on each of those aspects of the service, and you can just go in and do a quick just-in-time learning on that, okay? There's a help menu, which includes our toll-free number, the email for customer service, a very extensive and comprehensive user manual that you can look at, and there is a schedule of webinars. If I click on right here where it says webinars, you'll see that there's a list of webinars that are about an hour long. They're free. You can go in and attend any of these, for if you either wanted a refresher or an introductory class, you're going to get a good overview of what's going on with the service, okay? So here I have my search. I have wrongful with an asterisk, which gives me any ending on that word, within 9 words of terminate, or any form of terminate, termination, terminated, anything like that. And so I go in and do that search. And I have 403 documents, okay? And you'll see that Casemaker did the search not just in the cases, but in all of the material that's associated with the jurisdictions that I chose, the 3 different states that I chose. So you see there's some law reviews, some other materials, as well as statutes, as well as the cases. And what you're seeing in the center of the screen here is the first 2 items from each of those categories. And you can choose any one of these. If you're doing this particular research and you think, oh, wow, there's some Nebraska statutes right there, and maybe that would be a helpful place to start my research, I'll just go in and do that. That's perfectly fine. We're gonna focus on the cases today. So I open this up. Even though there's 400 of them, it doesn't matter. We're not going to look at all 400, but what happens is by opening up that category, it presents the devices or mechanisms for narrowing the search down. You'll see that there's only 86 of these are Nebraska. If I wanted to click on the Nebraska ones and just see those cases, I could just check that box, and now I'm looking at 86 Nebraska cases. And so if I review some of these and decide, okay, I want to go back, then I just uncheck that and I go back to my 400. And so very easy for you to manage your way and navigate your way around the material here, okay? Now you'll see that there's, you can separate this out by the individual courts, or you can narrow it down using the name of a judge or an attorney, all kinds of different things you can do. But I'm going to use an additional search term, and that's what people will do most often is they will add search terms that are going to focus and narrow this down to the conversation that you want, okay? I typed in the word whistle with an asterisk. I did that because I wanted to demonstrate how you kind of play a little bit of a word game when you are doing this kind of legal research, right? I'm anticipating that anticipating that this is a wrongful termination in the context of a whistleblower, okay? And so if you type in the word whistle with an asterisk, it will bring it up. If it's all one word together, all one word strung together, whistleblower, because that's exactly what the asterisk does, right? Gives you any ending on that word. But if the word whistleblower is two separate words, whistle space blower, then this will still bring it up because this will bring up the individual word whistle. And I'm banking on the fact that if I find the word whistle in a wrongful termination case, which is the universe I've already created, then it will be a whistleblower case, right? Okay, so that is, now this very first one brings up a kind of an amusing situation where sometimes, given the variations of the English language, we find, I don't know if you can read that from the back, but this is basically a railroad train failed to sound its whistle. So this is really not a whistleblower case in the way that I'm looking at it, right? Or that way that I want it. But it does point out the fact that it's very easy to identify cases that are not on point, and then you just, ignore those and move on. And the way that you would collect the cases that you do want, the cases that are going to be valuable to you, is by using a system of folders that Casemaker provides, okay? And once again, this is a part of the service. It's free. There's no limit on how you can use this. There are two different ways in which you can use our folders. And once again, there is a video that will describe this, so you can just, you don't have to remember it right now. Just go back and look at the video. It'll tell you very quickly how to do it. But there are two ways that you can use our folders, or two ways that you can get material into the folders. Just depends on your preference. So the first one, let's go in here and we'll see, I don't have a folder right now that is really designated for this particular client, this particular research. So I'm going to create a folder and I give it a name. We'll call it NEBAR. And so now it will reset that list, and that will be NEBAR will be one of my folders. I click OK, and now you can see that is the active folder. And now from this point, all I need to do is, as I go through and review these things, all I need to do is take them, drag them, and drop them. Now there is a reference, a link to the full text of that case in that folder that I have designated for this legal research project. I go through and I just, any ones that I find that I like, I just put them up in there, and easy squeezy, we just go through our list, and that is all there is to that, okay? Now, if you don't happen to be a drag and drop kind of person, you, in fact, are a checkbox kind of person, don't worry, we've got you covered, okay? So all you need to do is go down and check the box for the one that you like. I like that. I don't like that one. I like this one. You go through and you look at them, you open them up, you review them, you analyze them, and you decide you like it. You put a check mark, and you just go through your list of 47 or however many you have. And when you're all done, then you go over here where it says Save to Folder. And you'll see that NEBAR is one of your things. When I click on this, you'll see this little icon will open up. I simply say Save, and now all the things that I checked are in that folder. Very simple. So whichever way you prefer, dragging and dropping them or checking them, in they go. And again, what you're getting is a link to the full text of that document, okay? Anybody have any questions on any of this? I mean, I'm flying through this stuff fast, but I'm relying on the fact that you will go back and check the little videos or that kind of thing, and get a refresher on it. I'm just trying to show you an overview of the functionality that's available and the content and roughly the usability and how it works and that kind of thing. It's very simple. Yes, ma'am. Yes, every case, when I open up a case, let's say I open up this one here, which I have not already checked or put in there. I can open this case up, and save to folder is one of the options. And I can just click on that and save it into any folder. You know, obviously I'd probably do the one for any bar, you know. But yeah, so anytime you have a document open, you'll be able to save it to a folder. And so very simple. Again, there's no limit on the number of folders you can create. So if you have several different projects you're working on at a time, create a folder for each one. You can go back to them. And what I'll do now is I will go back to the home page. So before I do that, though, does anybody have any questions on the oh, there is one important thing I forgot to point out. Let me point out that in the list here, you will see that a lot of these cases have a red thumbs down. I hope that's, yeah, showing up as red here on the screen. Red thumbs down. Some of them have a green thumbs up, right? That is our citator. If you're using Westlaw, you know, you're probably familiar with that. It's called, their system is called KeyCite. Ours is CaseCheck Plus, and this is just telling you, yes, in the number of times this case has been cited, which in this instance is 97 times. That's what this little number over here means. How many times has this case been cited? 64 times. In that amount of time, there is no negative treatment of this case, okay? Nobody has cited this case and overruled it or reversed it or criticized it or anything like that. However, in this other case, within the 76 times it's been cited, some negative treatment has occurred. Casemaker tracks 15 negative treatments of cases. Overruled, reversed, modified, superseded, those kind of things which render a case, you know, very unlikely that you're going to want to cite that, okay? However, we also have things like criticized and questioned. So in those instances, and criticized is actually the one that comes up most frequently, but when I open this case up, you'll see what the negative treatment is, and in this case, it was criticized. You'll see that there's this case that criticized it is hyperlinked, and so I can jump right to that case and see where that conversation took place about the criticism of this, and then make a determination on whether I feel that I can still cite this case or not. It's really your call at that point. But if the case was overruled or reversed or modified or something, you definitely want to see that, and that's what this would give you, okay? All right. So let me go back now to the home screen, and I'll show you here in the area on the left here. You'll see my folder. And this is a list of the folders. If I go into any bar, then you'll see there's the items that I saved into the folder. And at this point, yes, sir. Oh, 2 minutes. Oh, my God. Okay. I thought you were just giving me the peace sign there. So, okay, at any point then, if you decide as you're reviewing these that some of these were not that helpful after all, now that I'm reviewing them in more detail, you can eliminate them, or you can just go ahead whenever you're done with this project, you can just go ahead and delete the whole file, okay? And so that's how that works. Let me go back in here to the home screen. Back to the home screen and point out that here's the mobile application I mentioned. You can sign up to have this available on the mobile app. It will ask you 3 questions: your name, your phone number, your email address. It will then give you a reference number, and you then go to your app store, upload Casemaker, and it will then ask you for the app, the reference number, and you type that in, bada boom, bada bing. You're now doing research, driving down Route 80 and doing legal research at 75 miles an hour, because you don't want to break the law, so. Anyway, okay, so Yeah, since I'm kind of running out of time here, and there's people coming in right after this, I will just kind of leave it at that, but throw it open to questions. Does anybody have any questions or comments or anything? If you've used Casemaker, is there any part of it that's been troublesome or confusing to you? Yes.
Regarding the site check, when you said it'll tell you the case has been superseded, are you referring to whether it's not the most recent case on the point, or?
No. Okay. Superseded typically means that this case was rendered, inapplicable by a statute. Very, very often, that's what that means. That it's been superseded. And like I said, rendered so uncitable, by a statute is usually what that means. So, but if it's overruled, a higher court can overrule it, and you'll see all of that, depending on the circumstances. Anybody else have a question? Yes, sir. There's not much in terms of secondary source materials. That is the one area where, say, Lexis or Westlaw have a great advantage, right? West has been publishing legal materials, treatises, and hornbooks and all kinds of things for more than a century. Lexis jumped into the business quite a bit later, but in recent years, they've bought up many of the other publishing companies, and they have copyrights on those, and so they're not available to us. We do have relationships with some other companies. For instance, you mentioned forms. We have a legal forms partnership with another company, but Sam likes to point out when I say that we have our own forms library called MedDocs. Right. Our association. On platform, we have over 800 forms in there. Right. So, for those of you who didn't hear that, NebDocs through the Nebraska Bar has over 800 Nebraska-oriented forms that you can use as part of their program. But if you are looking for a form outside of Nebraska, if you needed a California power of attorney form or something like that, you can go to our service. This is a partnership with an outside company, so there is a fee for that. I've noticed that the fees range from about $5 to about $50, depending on the complexity and the nature of the form. So, So, okay, I guess I should wrap it up then. But thank you all. I appreciate your attention. And if you're using Casemaker, thank you for that. If you're not, you might consider using it as part of your bar membership and comparing and contrasting to whatever other service you might be using. Okay? All right. Thanks very much.
Okay, next up we have Staci Hartman-Nelson. She's going to talk to us about client counseling and interviewing witnesses, and also about conducting and defending depositions. Staci of Hartman-Nelson Law Office in Omaha focuses her practice in the areas of litigation and negotiations, primarily within workers' compensation and personal injury. She graduated from the University of Nebraska College of Law and is admitted to practice in both the Nebraska state and federal courts. Thank you, Staci, for being here with us.
Thank you for inviting me. As I'm sitting in back, I'm thinking to myself, I have not been back on campus in 10 years. And I'm sitting here with my portfolio that I used in law school. So it's very nostalgic to be back, and really cool that after 10 years, this is the first time I'm back. So thank you very much. I don't know that I've had a captive audience like this for an hour and a half straight, so you may get sick of me, but I may have to kick off my shoes too. I don't know if I can stand in heels for an hour and a half. But I am first presenting on client counseling and interviewing. And we'll see if I can figure this out. I also haven't done a PowerPoint since law school, so this is going to be fun. Should be. Is it clicking? No. There we go. Client counseling begins at the initial consultation. While not always possible, I suggest that you always meet in person with a potential client. I do have some clients that are from out of state, and it just makes it impossible to do that. But really, this is the time when you can get an idea of whether your personalities jive. You're not going to be the perfect attorney for every client. If you do not like a potential client, guess what? A jury is not going to like them either. So you should probably listen to your gut on those things. The client is not only hiring you, you are accepting their offer of employment. Why would you want to take a case if you're going to dread working on it? And you maybe have been in this position where there's just a client who either never seems appreciative of anything that you do, or you can never seem to do anything right. Guess what? That file kind of makes its way to the bottom of the pile over and over again. It's not fair to the client, and it's not fair to you. So if you really get that feeling initially, maybe there's somebody else that would have a better personality or maybe style of lawyering for that particular client. If they lie to you at your initial interview and you still decide to take their case, I guess proceed at your own risk. You know, you've already found that they're going to be less than truthful potentially throughout your entire representation. I recently met with a potential client who had what sounded like a serious work accident. It, however, had been nearly 2 years since the accident, and he had not sought further treatment. I explained that from the defense perspective, a lot could have happened in those 2 years that they would like to say was the cause of his current symptoms as opposed to the work accident. My intake questionnaire asks things such as, do you have any pre-existing conditions? Have you had any other potential accidents or injuries that might affect this litigation? And his written response to the question was, no, none. But when I asked if he had been involved in any motor vehicle accidents since his work accident, his young son, who he decided to have accompany him to the appointment, piped up and says, yeah, Daddy was in a car wreck. It sucked. I had to walk to school for like a whole year. So he wasn't going to share that information, but I was sure happy that that young child was there to share it. So, whoo, bullet dodged, right? I don't have to take on that potential client who was going to lie to me at the initial interview and potentially take me for a ride that was going to cost me a lot of money, a lot of time, and a lot of, failed efforts. All right. This initial consultation is what I contend is when you should start managing the client's expectations. What does the client want? There you go. What does the client want? Are you able to obtain their desired result? You need to make sure that the potential client knows what possible recourse they have or what benefits they are actually entitled to before your representation ever begins. In my work comp cases, a client may often be angry that they've been fired by their employer. Unfortunately, there's very little that I can do in that regard. I can't make the employer give them their job back. All I can do is advise them that they have a statutorily protected right to pursue a workers' compensation claim. And if they think that they were fired in retaliation for their pursuit of that claim, they can certainly contact an employment law attorney to discuss a potential retaliatory discharge claim. So let them know what you can actually do for them. Outline the statutory benefits that they're entitled to under the Work Comp Act. Don't mislead them and make them think that they can get everything under the sun, because you're never going to be able to fulfill that promise. Next, and this kind of goes hand in hand, monetary expectations. What are the client's monetary expectations? What do they think they're entitled to? What do they think their claim is worth? Many don't know that an employer's negligence has no effect upon the value of their workers' compensation claim. No matter how agonizing their injury is, they're not entitled to compensation for pain, suffering, and inconvenience. They don't know these things if they've never had a work comp injury or claim before. So they need to know that to have their expectations managed in terms of what they may be entitled to when settling their case or obtaining an award from a work comp judge. If the client already has some dollar figure in mind, walks in the door, they've talked to their buddy, they've talked to their family members, and, well, this is what I got when I injured my back. I got $1 million. And they think that's what they're going to get. You really have to let them know that you can't compare one claim to another. It's apples to oranges. There's all kinds of moving parts that come into play. So you need to bring them back to reality. Some of the cases that walk in my door that I think are just easy slam dunk cases end up being the biggest stinkers I ever take on. And others that may seem super trivial, small matters end up being the most, I guess, fulfilling to handle because maybe the client is so appreciative that you're even willing to take it, but can also end up being the most profitable when it comes to the time that you have to put in to the amount of potential profit in the end. I always tell my clients, hopefully I'm still in the right place, who knows? Oh, no, don't show that one yet. Okay. I always tell my clients that unfortunately I do not have a crystal ball. So I cannot tell them the end result, what's going to happen, but all I can guarantee is that I will do my best to present the best case possible for them. Not only because I want a satisfied client that is going to go out into the Omaha metro area and sing my praises to everyone that they come into contact, but also because we have mutual goals, mutual interests. There we go. The more money that I can get for them, the more money that I can get for myself, and the more Legos I can buy for my children, which I despise Legos and stepping on them. Come on, give me a laugh. Just there we go. All right. Lastly, we've got, next on the list of expectations to be managed are the client's time expectations. How long is it going to take to bring this matter to some type of resolution? We all know that most legal matters are not resolved overnight, but clients don't always get that. If a client is not advised of how long a claim or case may take to reach resolution, you have not properly managed their expectations, and you may quickly have an angry and or apprehensive client on your hands. Last on the list of expectations to be managed is the strength of the case. This is why you must identify the potential issues and any problems that the case may have. After doing this, just be honest with the client. Talk those things through. There may be explanations for things that you think are issues. They may be non-issues if you just bring it to the client's attention. You, in fact, are the expert. As such, it's your job to explain what you view are the strengths and weaknesses of your case. Here, you must sometimes play devil's advocate and keep the client grounded and reasonable in their expectations. All right. Client counseling and especially witness interviewing are done to accumulate facts about the case. A telephone consult is typically that very first step in fact gathering. Support staff is often the ones that are taking that initial client telephone call or having that initial contact with a potential witness. As such, they are your first impression as well as your first line of defense. There is nothing worse than getting wrapped up in a client consult for hours in a morning or an afternoon only to find out that this potential client statute of limitations ran 10 years ago. And that's pretty easy to find out over the phone if that question is asked. So train staff to ask those proper questions so as not to waste your valuable time. All right, and then I already mentioned my intake questionnaire and how that gentleman says none when asked about pre-existing conditions or other accidents. But with this, I handle it differently in every case, often just based upon scheduling and what I have time for. But the initial intake questionnaire is very important. We've started providing that intake questionnaire before the initial consultation for the potential client to fill out on their own time. I think that this shows you how serious a client is about their case. If they're going to take the time before taking your time to meet and really go through and list the doctors that they've seen, maybe even look up an address or a phone number, that shows you that they're serious about their claim. They are going, when it comes time for discovery in their case, they are going to actively engage in the process. It's not, hey, I think I might have a case here. Why don't you take it and run? It's this client saying, I know I have a case. I need your help, and here's what I'm going to do to help you make it the best case possible. They also then can do it at their own pace. When they come to my office and I throw paper in their face and they're just trying to get through it and trying to look up this and that, they may forget certain things. And that's understandable. Sometimes they're very nervous. It may be the first time that they've ever met with an attorney. So I sometimes have them do it, though. They're at my office, fill it out, because really that's what you can use then as a roadmap for that initial consultation. So you can ask the right questions to gain the right facts that you need and determine if it's a case that you even want to take. The last one really is all about you and your sanity. Sometimes I don't have the client fill out anything before our first meeting, and this is normally due to time constraints. Many potential clients ask for appointments that are outside of business hours, after 5 o'clock. So if that occurs, I'll take the questionnaire, and when we're meeting, that's my roadmap, and we fill it out as we go. I ask the questions, and that's really to try and expedite the process so that I don't get home super late, which results in a super angry husband. So regardless of how it goes down, at the end of that initial consult, you need to if you take on the client, you need to remind them of a few things. First of all, keep in touch with your office. I've had people that become my client and then they disappear. If your phone number changes, if your address changes, it's as easy as a phone call to give us that updated information. I have to be able to communicate with you. What if an offer is made for $1 million and I can't even get it to you because I can't reach you? Just keep that line of communication open. Do not discuss the case with others and refer all inquiries regarding the case back to my office, and inform counsel of the identity of any additional witnesses, facts, or evidence that may arise. Okay, moving on. Once suit has been filed, fact accumulation really is acquired through the discovery process. You should conduct extensive written discovery. You should make sure that you get a complete set of all records subpoenaed by opposing counsel. And these voluminous records will often be plopped on your desk the day before your client's deposition. Just ironically, that's when they appear. Is this on purpose, Leslie? I'm just joking. That time, yes. I'm talking, okay. I was really teasing. Yes, but be prepared for this. So if a client's deposition is scheduled and you haven't received subpoena documents from opposing counsel, they're coming. Leave yourself time. I mean, you may get a stack similar to this, but the last thing you want to do is go into that deposition not having reviewed all of those records and potentially being blindsided by something damning that might be out there. All right. Prepare an issues memo based upon your review of the client's medical and employment records, as well as opposing counsel's discovery responses. The minute I get their answers to interrogatories, I'm scouring them just for any potential issues that I see. And then that obviously leads to more things that have to occur. But it really ends up being a spectacular outline for your depo prep with your client when that time comes. It should outline things such as if opposing counsel has discovered other accidents, injuries, medical providers, criminal charges, social media postings, or any other potential damaging information that your client may have failed to disclose. One example of this has already been discussed. Had I taken that workers' compensation case previously discussed, but became aware of the client's intervening motor vehicle accident the day before his deposition, that would probably be one of the main topics that we would need to be discussing in our prep before the deposition. Okay, so this motor vehicle accident, were you at fault for the accident? You know, how severe was the collision? Did you require any medical treatment as a result of that collision? Was it in, the grocery store parking lot? Those are the things that we would want to find out so that we can make sure that it's thoroughly explained during the deposition. With social media becoming what seems to be the preferred mode of communications these days, we probably better discuss how to deal with and advise clients to use or abstain from using this type of media. Some lawyers require their clients to really just not have a Facebook page, take everything down, get rid of everything during the pendency of any litigation. Let's say your client has sustained a low back injury that left him unable to perform his manual labor job for 6 months after the subject accident. During your representation of that client, he makes this his profile picture on Facebook. Well, because the client has that as his profile picture, anyone can see it, including opposing counsel. It does not matter that this picture was taken 2 years ago or that the grass was super long and it just had to be done. It doesn't matter. Even with proper explanation, opposing counsel is now going to either highly scrutinize or altogether dismiss your client's lost wage claim. So I would say it may be best, and I've never done this, but to just have your clients take a Facebook vacation or at least alter their privacy settings accordingly. All right, so now I'm supposed to talk about witness preparation. And I think so much of this overlaps, really. We've kind of been talking about witness prep and client prep, but when a deposition is scheduled, I typically send out my clients' answers to interrogatories for them to review. As previously mentioned, your issues memo should be the basic outline for that depo prep. And if a timeline or some other issue in your case is very complicated, it's okay to allow the client a summary, to take a summary that they have prepared or has been pre-approved by you to the deposition. Do, however, be aware that opposing counsel will be entitled to a copy of that timeline that is brought in, but there will be more about that in my next presentation. Next, you need to identify your client's fears and misperceptions. You really need to try and put yourself in your client's shoes or the witness's shoes. This is unfamiliar territory to them. Most of what they know about the legal system and providing testimony comes from television or movies. All right, no laughter there, that's cool. Try to put yourself in their shoes. We did that. Okay, before you explain what will happen at the deposition, ask them what they think will happen. You know, what's their idea? Maybe they've been involved in a different type of legal matter. You know, maybe it was a family law issue or vice versa. And obviously I'm talking from my own perspective. You know, I handle workers' compensation claims and personal injury claims. But if you're a family law attorney, a deposition goes a lot differently than a deposition goes in my world. So I guess take what I say for what it's worth. But, you know, ask them what they think is going to happen and just listen. Take note, listen to what they have to say. I don't know where I went here. Sorry. Okay, some common concerns heard are that the other lawyer will try to trick me with their questioning. The other lawyer will ask me yes or no questions and I won't be able to explain myself, or I will be nervous and I will forget things. After they've voiced these things, then you need to address their fears and misconceptions. Explain who's going to be present and what to expect. Oftentimes I'll have clients walk into the conference room and they'll, well, who's that? And it's the court reporter. You know, they're not teaming up on you and bringing multiple lawyers to really intimidate you. Court reporter's there just to take down the testimony. And if you explain those things to certain clients, that may resolve a lot of apprehension. If they are frightened of opposing counsel, you can explain that, you know, I do this all the time where I say, I've dealt with Leslie before. She's nice. She's fair. She's not going to, she's not going to yell at you. She's not going to be mean to you. She's really going to be straightforward. And that in itself eases major concerns for them. Remind them that you will have a chance to ask questions after opposing counsel really bombards them. So if there's anything that I, as their attorney, think that they haven't properly covered or maybe is still left in question, I can clean those things up. I can ask the questions in a manner that will allow them to present the testimony that they know is proper regarding a certain topic. All right, then just advise your client of the basics. Answer the question, avoid being evasive. If you're being evasive, the first thing that they're going to report back to their carrier, insurance carrier, is, yeah, this person, I don't know what they're trying to hide, but they're trying to hide something. And that's not what you want to have happen. Do not guess or speculate. Always tell the truth. You would think that's a given, but no. You know, even little white lies. Nope, none of that. Just tell the truth. Do not look at me before you answer a question. That's just in itself bad news. Typically, I'll kind of sit to the side too, so that's just not an option. You should be on the other side so that opposing counsel is who they're speaking to, not through you. And do not refuse to answer any questions. Oh, last one. Do not interrupt or argue with opposing counsel. That probably isn't something that will end up being good in a report back to a carrier regarding the strength of a case. All right, appearance is one of the last things that you probably should counsel clients and witnesses on. The clients, witnesses, I mean, they need to know that it's not just their appearance to opposing counsel at a deposition, but then it's going to become their appearance to a judge or a jury once it moves on to trial. You advise them to dress conservatively, but the problem is, what's conservative? That is really a term that is different to different people. I've said before, what's or I've said dress business casual, and it's what's business casual. So not everyone knows what that means, so I suggest telling them, wear what you would wear to a family wedding. And that'll even be different to different people, but you would think that's going to probably be the best thing that they have in their closet, and that's fine. Okay, why isn't it going? Okay, here we go. Advise your client of what you think are some obvious points about appearance. Depending upon their location and or the content, it might be a good idea to cover up visible tattoos and take out visible piercings. I don't think you would be able to cover up a lot of this gentleman's artwork, but yeah, you might be able to try. Do not chew gum or tobacco. Although, interestingly, a few years ago, I had a work comp trial in West Point, Nebraska, which is Cumming County, and the accident happened at a feedlot. And opposing counsel, the entire time that we're at Cumming County Courthouse, has a dip in. Opposing counsel did. So he's just chewing away the whole time. So I thought, well, maybe he's setting the scene, getting the judge, I don't know. It was interesting. Next, do not take prescription medications that you do not take daily. If it's your normal, to keep you normal, you take it. If it's not, probably not a good idea. And this leads right into the next one. Do not drink alcohol or utilize herbs to calm your nerves. Probably not the best idea. All right, lastly, probably best not to show cleavage, wear a short skirt, super high heels. I probably could have gotten you a better picture here, but we're keeping it clean. All right. I have no idea how long I have spoken, so.
You started at about 1:55, or 12:55. So if you want to go to 1:30, that goes back on track. It's up to you.
Yeah. Well, I'm really at the end, but you've likely utilized some good cop, bad cop tactics, and you've played devil's advocate as you have been preparing your witness for their deposition or as you've been interviewing witnesses at different points in time. So you don't want your client or your witness feeling or appearing overly depressed or like just degraded, like I just am done, my case is crap, this is just going nowhere. So after you do that, then you build them back up. Okay, here's the bad parts, here's how we're going to make it better, and here's how you are going to present just fabulous testimony that is going to just win over first opposing counsel and later a judge or a jury. So take some time to empower your client or witness to give that best testimony that they can. After all, it is their opportunity to be heard, and a little encouragement can go a long way. All right. All right. Like I said, this long of just me. Let's go. Maybe. All right. Raise your hand if you've ever worked as an investigator. Yes, you have. Come on. I see Magnum PI right there. No? Okay. How about a director? How many of you have ever directed a play, a musical, or a movie? None. Okay. How many of you will never raise your hand no matter what question I ask you? Yeah. Okay, there you go. All right. That's fine. What I suggest to you is that as trial attorneys, well, as attorneys, and especially as trial attorneys in particular, we are all investigators and directors. A great investigator gets all the facts necessary to tell a compelling story, and a great movie director shoots a ton of material to capture facts and present a cohesive storyline. Where do we as trial attorneys get those facts and that material that we need to tell a captivating story. Wait for it. Discovery! Yeah, it's discovery. And where do you think you get the best information or facts? Is it from your written discovery or from deposition testimony? This is supposed to be interactive now. But you can't answer. Shit. It's deposition testimony, yes. And why is that? Clearly, there's too much in written discovery that's left to interpretation or semantics. There's just too much wiggle room, and word games can be played. It depends on, definitions of certain words. And I've had it happen over and over again where I ask an interrogatory and I get back, oh, that's just broad, unduly burdensome. So then you have to narrow and narrow and narrow. At some point, I really think it's that you become so annoyed by the process that you give up on it. But if you don't give up, you're going to finally get to that point where hopefully you will get the information if the opposing party is being fair and honest. And that just simply does not always happen. So, in my practice representing injured individuals in workers' compensation and personal injury matters, I do more defending of depositions than I do conducting depositions. So that's what we're going to cover first, is the defending of those depositions. Deposition should be used as a way to discover the strengths and weaknesses of your case, as well as that as of the adverse party. I've already spoken about some things that will apply to this topic in my last presentation, so if anything sounds familiar, I apologize. Okay, defending depositions. When opposing counsel asks to take my client's deposition, I send out the notice along with their answers to interrogatories. And I didn't always do this, but really they've helped in preparing those answers. And that's typically an outline of what opposing counsel uses for their deposition. So that's many of the questions that are going to be asked of the client anyway. I also send out a general informational sheet about depositions. This is to help identify and address some of those client fears and misperceptions about the deposition process right out of the gate. In preparing this presentation, I went over my deposition information sheet, which I thought was just so basic. And I decided that it probably could use some revamping after all these years. I think, there were things that could be more informative in some places and some things that could seem much less harsh. But we're going to take each of these in turn, and I hope it's somewhat informative. I guess it's what I do. So, all right. First is you let them know that the court reporter will type every word or sound made by any person attending the deposition. What you say may be used against you. You must tell the truth. If you don't, you may be subject to criminal charges for perjury. This should be an instruction given not only to your client or witness, but to anyone allowed to attend the deposition. Often people will ask if their spouse can attend as a moral support, but you need to make sure that they are all aware that anything said will be in the deposition transcript. I had a client who wanted their friend to accompany them in, and oh my, things just went haywire when the friend wanted to start piping up and offering information. Well, ultimately, opposing counsel, after the conclusion of my client's case, said, well, hey, while we're here, how about I just depose the friend Jane as well? Well, yeah. With all that she had to say about the situation, it completely made sense. So, unfortunately, you have to maybe somewhat find out if that person is going to be able to keep their mouth shut while being that source of moral support in the conference room. Oh, the threat of perjury, I guess, in that deposition information sheet, it seems harsh, but it's true. I mean, how often does it happen? Not very often. But I guess it's a little bit of a scare tactic, just to let them know, you tell the truth. You just tell the truth, and then we won't have any issues. And if they do that, then the penalty of perjury is a non-issue. All right, the next one is if you're not 100% certain of an answer to a question, it's better to say, I don't know, or I don't remember, rather than giving the wrong answer. No guessing, you either know the answer or you do not. If you need to clarify in order to answer a question, state that instead of providing a less than certain answer. On the other hand, don't be a jerk and make opposing counsel's life miserable. And I had a case where I went and deposed 3 Spanish-speaking gentlemen at a meatpacking plant. And at that meatpacking plant, my client's hand had been severed by a meat press. A meat press that should not have ever been able to press had the safety mechanisms not been altered. So I go in to depose the supervisor, who, mind you, was the brother of my injured fella, and 2 other people that were listed as witnesses who had knowledge. And I tell you what, through an interpreter, every question that I asked of these 3 gentlemen, the canned response was, to the best of my recollection, I cannot recall. To the best, for 4 hours, I asked questions and got, to the best of my recollection, I cannot recall. Where do you think they came up with that verbiage? Counsel for the defendant. And that's when I leave angry. It's not fair. I'm playing fair. They should play fair too. So that's my soapbox on that one. All right. The attorney on the other side of the table does not represent you. His or her job is to try and obtain information that can be used to impeach you at trial. This means that he or she may try to trick or confuse you. May. It probably depends on who's on the other side. Simply tell your client to think before they speak. Take your time, relax. Don't agree to anything that opposing counsel asserts if it's not 100% accurate. If you're not sure what opposing counsel is asking, it is permissible and expected to ask them to repeat the question or explain it in a way that you can understand. It is the job of the attorney asking the question to ask it in an understandable manner. It's not your job to interpret or try to figure out what is on his or her mind. Answer the question and stop. Do not go off on tangents. Be as clear and concise as possible. If it's a yes or no question, simply answer with a yes or no answer. If you feel the need to elaborate or explain, that often means that the question was not clear. I tell my clients that if I, as the attorney, think that further elaboration needs to occur on a particular topic, that I'll be sure to cover that when it's my turn to ask the questions. If your attorney objects to a question, that typically means that there's something about the question that they probably don't like. But you are still required to answer the question. And this is going to be a little bit of a contradiction later on, but if there's a problem with it, it's probably compound. Oh, where am I? Sorry. Okay, yeah, unless your attorney tells you not to answer, you have to answer the question, even if it's objected to. Review your notes, records, answers to interrogatories, petition and or complaint in the days preceding your deposition to help refresh your memory. This should lead to more concise testimony being presented. And lastly, if you want to present yourself in the best light possible at your deposition, or you want to, and if you want to, you should dress in business casual attire. And that's when one of the things that I was reading thinking, maybe I better elaborate on this a little more in my information sheet. Or like you're going to a wedding or to church. And we covered that topic extensively in the last presentation. So we'll leave it at that. When the deposition commences, as counsel, you only have 2 jobs. Number 1, you must listen during your client's deposition. I have attended depositions when the attorney representing the deponent doesn't take one note and is literally falling asleep. Sad. Because some good stuff is likely being missed as he's getting his afternoon nap. He or she is getting their afternoon nap. If opposing counsel is asking repeated questions about a particular topic or some issue that maybe wasn't on your radar, that should be a little bit of a flag. Why are they asking this? There is a reason. You're going to want to try and figure it out. It might be appropriate to talk to your client about that line of questioning during a break so that you can deal with it or clean up that testimony prior to the conclusion of the deposition. You must, however, keep in mind that opposing counsel can ask what you discussed with your client during the break. More about that to come. Second thing that you need to do is observe your client, especially his or her nonverbals. Your client or your witness's deposition presents a great opportunity to identify areas that need improvement before trial. Does your client come off angry? Do they appear defensive? Do they ramble? Do they mumble? If you can't understand them, a jury's not going to understand them. So if you need to get a speech pathologist and help them to enunciate better, if that's what's necessary, that's what needs to take place. Make note of these specific weaknesses so that you can refer to it and address those issues when prepping your witness for trial. All right. So that was defending depositions, which kind of overlapped with interviewing witnesses and clients. Now it's conducting depositions. Be kind to the witness. That's kind of, is it blurry up there? You'll catch more flies with honey than you will with vinegar. Get them to loosen up. Get them talking about something that they're interested in that has nothing to do with the litigation. We are much more likely to share freely when we feel comfortable. Get them feeling that they can be comfortable with you, that they can share with you. When I was clerking over 10 years ago, I was told that if I had done my job properly, when the deposition was concluded, the witness should be asking me to go have a beer with them. Because we're now buddies, we're friends. Why can't we? I'm the nice person. I wasn't doing anything besides just asking for information about their claim. They certainly should not be viewing me as the enemy at any point in time. Sometimes I'm good at that, other times I'm not. It depends. Depends on the nature of the case and maybe who the person being deposed is. And some people you'll be able to win over, and others it's just never going to happen. All right. Before taking a party or witness's deposition in any case, you must determine what exactly you wish to accomplish by taking the deposition. A deposition might be taken for one or more of the following reasons. To preserve testimony. This may be of an elderly or ill witness or a witness who will not likely be subject to the subpoena power of the courts at trial. To learn everything the client or witness knows about a particular subject. Let me back up. To pin the witness down on a particular set of facts. Sometimes we're trying to paint a witness into a corner so that their testimony can be relied upon as you're moving forward towards trial. Sometimes it's to build an arsenal for cross-examination of the witness at trial. I must admit that I am not very good at this. When I depose a witness, I rarely hold anything back. It's like I want to get everything out there. I want all the facts out in the open, and I want to know what they have to say about anything related to the claim. That, however, means that I'm showing opposing counsel my best arguments. And if there's any way to coach that witness to make those best arguments get weaker and weaker, that's what they're going to be doing on their side as we move towards trial. So I need to get better at that somehow. Another reason for a deposition is to obtain enough information from the witness to lead to other discoverable information. And lastly, you may depose a witness to portray, I don't know what that was supposed to say. Lastly, you may depose a witness to convey the strength of your slam dunk case to the defendant and their attorney in an attempt to promote a settlement early on and avoid lots of costs down the road. Whatever the reason for the deposition, just make sure that those reasons are in fact identified prior to the deposition occurring. If it's likely that the deposition may be used at trial to impeach the deponent, it's essential that certain questions are asked to prevent the deponent from wiggling off the hook during your cross-examination. So, and I think this is straight from the manual that the Nebraska State Bar Association would like all of us to purchase. But it does give a list of beginning questions that you should lay forth before the deposition begins. Background questions: name, address, occupation, prior experience with litigation and giving depositions. You should ask about how they have prepared for their deposition, including what documents they have reviewed, if they have had conversations with anyone about the subject matter of the litigation, including if they've spoken to opposing counsel, although you can't then ask for the subject matter or content of those discussions. Be sure to go over the deposition ground rules, such as the fact that you will assume he or she understood your question if he or she answers it, that they may ask for a question to be rephrased if it is not understood, and that they are permitted to take a break if needed, but that you request, if there are any posed questions still pending, that those are answered prior to the break being taken. Finally, they must verbalize all answers, no head shakes, shoulder raises, uh-huhs, uh-uhs. When you are conducting your deposition, it's okay to use notes, an outline, or a checklist during the deposition to make sure that you have covered every area of testimony that you intended to cover going into that deposition. But you should refrain from attempting to stick to a script. I have gotten better at this over the years, but I still like to have my detailed script as a backup. The problem is, as you do that, you're not listening necessarily to everything that is being potentially spilled by a client, or not by your client, but by the witness. You want to be able to listen to each answer given by that witness to see if it prompts further questioning and not simply skipping to the next question in your script. A prime example of this just happened to me last week, actually. So I had my entire deposition outline ready to go, and I knew exactly what the purpose of this deposition was. My client tripped and fell going into a gas station. The defendant's answers to interrogatories indicated that there was a 3-month cycle for their surveillance video footage. So every 3 months, it gets recycled and taped over. That was their answer to an interrogatory that was posed. Okay. The defendant also alleged that they had never been instructed to retain, maintain, and not destroy or spoliate the surveillance video footage from the date of the accident. I, however, had correspondence from counsel to the manager of the gas station dated 60 days after the accident, stating specifically, quote unquote, "Since litigation is likely, I trust that this video has not been destroyed or somehow misplaced." Based upon the defendant's discovery responses, that's from them saying it's a 3-month cycle. Well, if you were on notice and told not to destroy that evidence within 60 days of the accident, I should get a spoliation instruction from the judge at trial. Well, based upon that evidence, based upon the defendant's discovery responses and that documentary evidence, I requested a 30B6 deposition of the representative of the defendant who had the greatest knowledge regarding the policies and procedures regarding viewing, storing, and maintaining video surveillance footage obtained by the defendant at the subject gas station. And I based all my questioning on the representations made by the defendant in those discovery responses. So my script is all based upon painting him into a corner about all those things that I had been told. Well, lo and behold, when I arrive at opposing counsel's office for the deposition, he informed me that contrary to their answers to interrogatories, the surveillance footage is only maintained for 30 days, not 3 months, as they had previously indicated. So how convenient for you the day that I'm here to get exactly what I need, that we're just going to change that answer real quick. So my script with all of my questions focused on pinning their representative down and getting that spoliation instruction. I mean, it was out the window. And maybe I should have just canceled the deposition that day. And all the prep that I had done, maybe I just should have said, screw it. Nope. The show must go on, and it did. And I still got some good stuff from him, but if I was simply tied to that script, it would have been of no use to me at that point. All right. Inevitably, in your practice, you will come into contact with a few Eddie Haskell attorneys, and this is, I don't know if you can read that or not. Some may be too young, but I don't know that many of you out here. So some may be too young to remember this character, but Eddie Haskell was a character from the popular 1950s sitcom Leave It to Beaver. And Eddie was very polite and respectful to all the parents and the elders, all the while he is just a bully and a pest to poor Beav, who was such a nice kid, right? Eddie Haskell's main agenda in life is manipulation while trying not to be obvious about it. And if he ever does slip up and let that side show, he simply says, oh, I was just kidding. If you encounter an Eddie Haskell attorney in the deposition setting, you'll have to use some tools, the following tools, to thwart his or her manipulation tactics. And here's where I'm going to start going straight from slides. So, you start with the rules of ethics. In the Model Rules of Professional Conduct, Rule 3.4a states, A lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully conceal a document or other material having potential evidentiary value. There is a landmark case of Hall v. Clifton Precision, and it states that the purpose of a deposition is to be a question and answer session between a lawyer and a witness aimed at uncovering the facts in a lawsuit. When a deposition becomes something other than that because of strategic interruptions, suggestions, statements, and arguments of counsel, it ceases to serve the purpose of the Federal Rules of Civil Procedure, to find and fix the truth. So the Hall case then lays forth some standards. Defending counsel can make no objections except those that would be waived if not made under the Federal Rules of Civil Procedure 32D3B, such as form and those necessary to first assert a privilege, second, enforce a limitation on evidence directed by the court, or present a 30D motion to terminate a bad faith deposition. Therefore, any other objections need not and shall not be made during the course of a deposition. At the beginning of depositions, we say, okay, stipulate form and foundation. Just very quickly, we got to stipulate form and foundation, and then no one follows those rules. So this can be question and answer if you want to wake up after lunch, right? Is conferring with a witness during an active deposition improper? Anybody? Okay. No, except a deponent and, did I read that right? Is conferring with witness during an active deposition, it's improper, except a deponent and the deponent's attorney have no right to confer during a deposition in a civil proceeding except for the purpose of determining whether a privilege shall be asserted. Okay, and here's what we talked about before. If something's being asked about and this line of questioning is just going and going and you're thinking, what is this all about? So you say, take a break and you're going to talk about it. Is it okay to confer during a normal break? Apparently there's a split of authority on this. The majority view is that conferences between witness and lawyers are prohibited both during the deposition and during recesses unless the purpose is to determine whether to assert a privilege. When such conferences are used to determine whether to assert a privilege, the conferring attorney should place on the record the fact that the conference occurred, the subject of the conference, and the decision reached as to whether to assert a privilege. So then the minority view allows defending attorneys to confer with their clients during breaks only if the defending attorneys did not request the break, which seems funny to me. What questions should you ask to make a record of the communications that may have occurred during a deposition break between the defending attorney and the witness? So here's some sample questions for the minority jurisdictions. Are you ready to proceed with questions? Did you have an opportunity to meet with your lawyer during the break? They're going to say yes. You can't then say, okay, well, what'd you talk about? But you can ask them, is there anything about the prior testimony that you presented that you would like to change? If so, what is it that you would like to change? Then the question is, isn't the damage already done? When they've presented testimony, then they've conferred with counsel, and then they've come back and changed that testimony. Not necessarily, but jurors do distrust information that they believe lawyers have manipulated. So in majority jurisdictions, you can go that step further. You can ask, how long did you talk to your lawyer during the break? You can ask about the content of that conversation. You can ask if they looked at any documents, if they looked at any texts or any emails, and why they looked at them. What did you review? Is that leading you to change your answer? And why is it leading you to change your answer? Why didn't you tell us that when you were first asked? What did your lawyer say to cause you to change your answer? And why didn't you have this information the first time you were providing testimony? To the jury doesn't apply here, sorry. All right. This is the main thing that we see in deposition testimony is the objections from opposing counsel. And the rules regarding objections are Rule 30C2 and 30D, which govern objections and depositions. Substantive objections such as hearsay, relevance, competency, or materiality are preserved. Error objections, meaning those that you can correct on the record, such as form or sufficiency of the oath, are waived if not made during the deposition. An objection is to be stated concisely in a non-argumentative and non-suggestive manner. This is the main one that I think happens all the time. Speaking objections, answers to questions, objections that suggest answers to questions are commonly called speaking objections. They occur when the defending attorney actually engages in coaching the witness. Some examples: objection, foundation. You can answer if you know. Objection, form. You can answer if you understood the question. That's a wink, wink, nod, nod to the client. You don't get it. Don't answer that. Ask them to state it a different way. Do something because I don't like that question. Well, are speaking objections allowed? No. Instructions to a witness that they may answer a question if they know or if they understand the question are raw, unmitigated coaching and are never appropriate. The if you know technique is actually sanctionable misconduct. I've had this happen too, where you ask a question and it's just a free-for-all and the other attorney wants to then restate, well, is this what you mean? Well, that's not proper. Well, is that proper? No, it's not proper. A witness may seek clarification, definition, or explanation of words, questions, or documents only from the deposing counsel, not from their counsel. It essentially allows the defending attorney to answer the question first, with the witness then adopting that answer. Objection calls for speculation. Are speculation objections proper during a deposition? I think I got a head nod, at least. No, they are not. An objection that a question calls for speculation is a foundation objection and not a form objection. Thus, under Rule 32, the objection is preserved and therefore unnecessary and improper. It also tends to coach the witness to say that they do not know the answer or they cannot answer. Objection, asked and answered. Examples, I think he's already answered that question. This is probably after hours have passed and you're just really trying to get something out of this witness. Whether they like it or not, you're going to drag them kicking and screaming, but they're going to agree to something. And the opposing counsel decides they're going to start saying that it's repetitive or it's been asked and answered. Well, is that proper? No. I can ask it as many ways as I want to. And he has to answer my question each time at a deposition. These are not objections. They are inappropriate, prohibited interruptions to the flow of my deposition. Objection irrelevant. Is that proper? No! Courts have firmly prohibited objections based on relevance. If there is a legitimate concern as to whether the discovery can lead to admissible evidence, those objections must be raised in a motion for protective order. Objection, improper foundation. Proper? No. An objection to improper foundation is a relevance objection. Therefore, like other objections about relevance, it is improper. Objection form. Proper? Now I got some. Yay! Yes! Deposition objections ordinarily should be limited to those under Rule 32D3 that might be waived if not made at the time. Objections on grounds that might be immediately obviated, removed, or cured, such as the form of a question or the responsiveness of an answer. Objection vague. I think you know where we're going. Proper? No! Courts have ruled that an objection about vagueness is prohibited as a speaking objection. The advisory committee notes explained that the making of an excessive number of unnecessary objections may itself constitute sanctionable conduct. And sanctions really is the only stick we have to keep the defending attorney in line and allowing you to conduct your deposition in the manner that you want it to be conducted, to get the flow that you need. When opposing counsel and I think I just skipped to where I shouldn't have, but when opposing counsel makes improper objections, what do? You have to simply build a record. When they make objections other than form, make a simple statement on the record requesting that there not be speaking objections. Say, please do not make suggestive comments in the presence of the witness. So you've done it once, and then it continues. What do? You stay calm. You remain professional. You keep your cool. And you simply and politely continue to state, please do not make suggestive comments in the presence of the witness. Then you insist that that witness answer the question as it was presented. When the next speaking objection occurs, you repeat the process. Do not engage. I think it would be hard. If I, in the situation that I'm laying forth, if that's going to happen over and over and over again, it would be difficult to not engage. What do you do when counsel instructs his witness not to answer your question? We've presented that that's not proper. No matter what, they need to answer whatever question is presented. Rule 30C2 provides that an attorney may instruct a deponent not to answer only when necessary to preserve a privilege, enforce a limitation ordered by the court, or to present a motion under Rule 30D3. Instructing a witness not to answer a question for any other reason is sanctionable. And once again, sanctions is all we have to get that accomplished. So the court may impose an appropriate sanction, including the reasonable expenses and attorney's fees incurred by any party on a person that impedes, delays, or frustrates the fair examination of the deponent. All right, that's all I got. I don't know how I am on time, but thank you very much and have a great day.
All right, we'll get started again. Next, we have Lindsay Belmont. She's going to talk about case analysis, screening, and preparation. Lindsay's with Koenig, Dunne in Omaha, and she specializes in family law. It was named the Best of Big O's Best Divorce Attorney in 2016. Before joining Koenig Dunne, her legal career was in the areas of child advocacy, child support, and litigation. She graduated from the University of Nebraska College of Law. Thank you, Lindsay. All right, thank you for that introduction. Again, my name is Lindsay Belmont, and I am a family law attorney with Koenig Dunne in Omaha. What I want to talk with you guys about today is case analysis, screening, and initial preparation. So throughout the presentation, I will give you examples on how my firm analyzes, screens, and prepares for new cases. But just so you know, every firm is different, which I know I'm sure you've all experienced. But the overarching principles remain the same. We're governed by the Nebraska Rules of Professional Conduct, and those are the guidelines and rules that we need to practice within. So my intention for today's presentation is to give you insight on how case analysis, screening, and preparation actually function in everyday practice. The rules are there, but the question is then how do you implement them in practice? So like I said, I will tell you about some of our firm procedures and give you examples on how we've narrowed the rules to stay within the confines of our ethical obligations. One of the reasons I was interested in speaking on this topic today is because practical skills-based knowledge is crucial for new attorneys and experienced attorneys alike, law students as well. And we know that law school doesn't always teach you how to be a lawyer, and that comes with practice. And with practice is trial and error. So I want to give some practical skills that you can walk away with to help you navigate some of the most important steps when a prospective client calls and seeks your services. If there are any questions or comments throughout the presentation, please feel free to interrupt me, and I will do my best to answer your questions. So the first piece I want to talk about is case analysis. And just know these three areas are all interrelated, but let's break it down a little bit. So case analysis. You get a cold call from someone saying that he or she needs an attorney. So immediately your brain starts churning with a million questions. You know, you'd go into legal mode. What do I need to know? And you're just trying to figure out what you can do to help this person. At the same time, you have to remember the person who's calling in also has a million questions in his or her head. So it's your job to gather the crucial information that is needed to determine whether that person should actually come in and have a consultation with you, whether that person would be better served by getting a referral to a better suited law firm or attorney, or whether, you know, a legal remedy might just not be suitable for the facts at hand. So for new attorneys, experienced attorneys alike, you might have that desire to help every person who calls in or comes in to talk with you. You know, that's one of the reasons why a lot of people go to law school. They want to help people. That's one reason I went to law school. And you want to provide the services that you went to law school for. But you need to know that taking every prospective client who calls or comes in is not an obligation that you have. A skill you need to know is that you're not the right fit for every prospective client, and not every prospective client is the right fit for you as an attorney. There are cases that you should not take. So in the materials that you have, there are some really great considerations that you should ask whenever somebody calls in seeking legal services. So the first one is, can you ethically accept or refuse to accept this case? Just a broad question for you to consider when this person on the other end of the phone is telling you what their situation is. Is it practical for you or your firm to accept this case? Now, like I said earlier, I work at Koenig Dunne, which does family law and bankruptcy matters. So if I have somebody call in who, you know, the facts that they're telling me sound like a personal injury case, that's not practical for me or my firm to accept. So in cases like that, I would get the referral sheet out, find a trusted advisor who does specialize in personal injury, and give the prospective client that referral. Consider whether what you're hearing, if there's a meritorious claim underneath it. Is the legal system the right remedy? Can you help them that way? You should consider whether the representation of this prospective client would create precedent adverse to other clients in the firm. So just keep in mind all that you have going on presently. Would having this new client come in adversely affect any of your current clients? One question that we consider a lot in our practice area is this a case that will cost more to litigate than what it's actually worth? So in domestic relations cases, you can see spouses arguing over who gets the couch. Well, maybe the couch is worth $100 and your attorney's hourly fee is $200. Is it really worth it to take that, to tell this person, yeah, let's argue over this $100 couch, but you're going to lose money paying me? Something to consider. Also in the realm of domestic relations is the issue of parenting time. People come in, they're mad that their former spouse isn't exercising parenting time, issues like that. And it's hard to look at that prospective client and say that this probably isn't the best route for you to take because it's going to cost you thousands to get before a judge, and the judge is just going to say, there's nothing I can do. I can't force your former spouse to be a parent. So that's one consideration, is the cost. You don't want to just be having your client incur legal fees when they don't need to be. You should consider whether this potential client's expectations are achievable. And in this, you really just need to ask the open-ended questions, really see what their intentions are, what they care about most, and then question, are you able within the legal system to achieve their expectations? And just have the honest conversation with the prospective client. If what you're hearing is not something you can help them get, let them know that, or else a few months later you're going to have a very upset client who's spent thousands in legal fees and not getting their desired outcome. You also want to question whether working for this client would create undue stress for you or your staff. And again, this isn't an exhaustive list of considerations, but just things you should keep in mind when that person calls in and you're trying to decide whether you want to take this case. So one thing that my firm does is whenever we meet with a potential client, we let them take home with them how to choose your lawyer. Because like I said, it is a two-way street. You want to make sure that you are serving the clients who you trust, who you think you can help, but you also want the client to feel supported by you and that they should be able to trust you and communicate with you. So one important thing to note is even the most experienced and skilled attorney is not right for every client. And that's hard when you're in the area that I practice in, because we do deal with emotions, we deal with very sensitive issues, and you might have the most brilliant legal mind, but if you're not connecting with that client or that client's not connecting with you, that's something to consider in whether or not you want to take their case. Additionally, one of our protocols in the office is at the end of our consultations, we don't give that prospective client the idea that, yes, we're going to take your case. There are things to consider. Talk with your managing partner, see if it's something that the firm can handle, and just be upfront with that prospective client that you'll get in touch with them, keep the communication open, and tell them whether or not your representation is going to work out. So that's some of those very initial questions, considerations that you want to think about when somebody calls in. So then the person's called. You need to figure out whether you can actually talk with them now, whether you can give them legal advice. So this goes into the realm of conflicts of interest. So the main question you need to keep in your mind is, will this representation be fair, remain fair, and appear fair during the pendency of this action? So if you're questioning any of those three questions, you need to take a minute and look deeply at why did you pause at any of those. a good idea is to have a screening process in place. And what I mean by that is it could be as simple as just keeping a log of people who have come into the office and met with any of the attorneys. After you have all those names in that database, when subsequent people call in, you just cross-check. See if, in domestic relations, if I've talked to husband and now wife's calling, I can't talk to wife. So you just want to be very diligent in keeping those records so there is no conflict of interest. So some ways that you can do that: when you are on the phone with the person for the first time, you want to gather as many facts as you can. You want to ask them who else could be involved in this suit. Are there any other individuals or entities that could be parties to the case? Then again, you just cross-check those names. You want to ask the names of the person or entities which will pay or be required to pay any claim, including insurers. Names of known witnesses that can come into play if, let's say, a known witness was a former client or a former opposing party, just some considerations to keep in place there. You can also ask, has this person been represented before? Are there any other attorneys involved in the case, which could provide a potential conflict? So, in the fact gathering stage at my firm, we have a very specific list of questions that we ask every person who calls in and says they want to come in and meet with one of the attorneys. So, and again, this is more tailored to domestic relations cases, but a lot of the principles remain the same. So we ask first name, last name, obviously. We want to know what county he or she is a resident of. We ask for a safe phone number, and why I say safe is because in domestic relations there can be domestic violence, or if the soon-to-be former spouse doesn't know that person is coming in for a consult, you don't want to end up calling that number back or leave a voicemail and cause further problems. So those are some of those initial questions we ask. Then we get into who could be the opposing party. We ask for their first name and last name. And if that passes the conflicts check, we continue with our questions. We move into more of the content of what's going on. So we want to know what kind of matter it is. And this, again, a lot of this initial process is just communication, getting the information that you need. So the person calling in isn't necessarily going to say, I have a custody case or a modification. They're not going to know those words. They're just going to start telling you facts, and then you need to decipher what they actually need. So in that information gathering, we decide what kind of matter it is. We ask whether there are any orders in place, any decrees in place, if there's an action currently pending. And again, you just have to phrase it into terms that prospective client would understand. Have you been served? Do you have a paper called a voluntary appearance that you want to come in and have an attorney look at? Are you currently represented? And if you are you unhappy with that current representation? Some of those questions. Also, when they call in, a good question to always ask is, do you have a court date coming up? We've had people call in on Friday and they have trial Monday. So, of course, we decline that representation because that would be impossible to prepare for trial and give competent legal representation on Monday. That's just asking for malpractice or a bar complaint. So those types of questions you're going to want to ask. Remember, though, if a prospective client says, I have trial next week, keep asking questions, because trial to them could actually be a motion to compel discovery. All they hear is court date, trial, judge. So just ask those questions, get as much information as you can to see if this is someone you should meet with. We ask the person on the phone about their employment. Where do you work? What's your job title? We ask about the opposing party's place of employment. And then we try to narrow down what the major disputed issues are, just to give us an idea of what kind of case is coming through our door. Another way that we really like to serve our clients is by matching up the prospective client with the attorney who we think they would work best with. So each attorney in your firm is going to have different strengths, different weaknesses. Some might be more litigation focused, some might be more settlement focused. So it's good to have a variety and to know which attorney could best suit this prospective client. So after we get all of that information, we still need to further assess for any potential conflicts. So as you can see, this is a huge area before this person's even going to come in the door. So the potential conflict, you'll want to look at the Nebraska Court Rules of Professional Conduct, Section 3-501.7. And I'm just going to go through these with you. Number 1, a lawyer or its firm cannot represent two parties to an action if their interests are adverse. Consent is not enough if a disinterested lawyer would conclude that consent should not be given. So this is a huge one that we run into in the domestic relations area. We have husband and wife who want to share an attorney, share the legal fees, be done with it. Well, we cannot do that because their interests will not be aligned. So you just have to have that upfront conversation. Again, communicate. These people calling in don't know the legal system usually, and just be very clear with them. You can't, this won't happen. A lawyer or firm cannot oppose a present client on the same or substantially related matter without the client's consent. Under certain circumstances, a lawyer or firm cannot advance inconsistent positions on behalf of separate clients before the same judge or forum. A lawyer or firm cannot accept a case where either the lawyer or a member of his or her firm could be a material witness to a fact in controversy. A lawyer or firm cannot have a financial interest in a case other than to acquire payment of costs associated, or cost advance for the client or the share owed under a contingent fee arrangement. A lawyer or firm cannot have a financial connection with the client except with financial transactions consistent with the client's ordinary course of business. A lawyer or firm cannot oppose a former client on a substantially related matter. And this is one I want to talk a little bit more about because I had it come up recently in a case and I want to share that knowledge with you guys. So this could come up if you think that opposing counsel should be recused or if opposing counsel thinks you should be recused. So you will want to know one case. It is Jacob North Printing Company versus Mosley. That site is 279 Nebraska 585. It's a 2010 case. So in this case, it lays out exactly what a court's going to look at to see whether there's a conflict here, whether you should be recused or whether opposing counsel should be recused. So some considerations in this. The rule that's referenced says that matters are substantially related for purposes of this rule if they involve the same transaction or legal dispute, or if there otherwise is a substantial risk that confidential, factual information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter. So this is just getting into, are these two cases substantially related such that there's a conflict? So to give a little context, in this case specifically, it was a breach of contract issue versus allegations of conversion and misappropriation. In the case, the court looked at the witnesses were different, with the exception of the former client, and found that the two cases were not substantially related. The Nebraska Supreme Court in that case also asked whether the attorney in question had an intimate relationship with both cases. If that attorney was significantly involved in both cases, there's a good likelihood that that former client would be prejudiced. So after that, the court also looked at, did that former client present any evidence that the attorney in question has knowledge regarding the former client's trial and negotiation strategies, legal theories, business practices, and so forth. So in their former representation, did that attorney gain knowledge that he or she only would have had for virtue of being that person's attorney? You can also consider the length of time between representation. In Jacob North, 3 years had passed, and the court found that to be to weigh in favor of not disqualifying the attorney. The court also rejected saying that the appearance of impropriety is enough. So it might look questionable, but that alone is not enough to disqualify an attorney. And then, of course, you have the catch-all. Consider whether, if you disqualify the attorney, what kind of hardships would that result on the parties and the judicial process as a whole. So the takeaway from that is this one, it'll come up. And make sure you have that case site in hand in case you need to defend against recusal or use it to your advantage if you want the opposing counsel to be recused. All right, the next one. A lawyer or firm cannot be compensated by a third person for legal services rendered unless the client consents and the lawyer's relationship and duty remains with the client. The easiest way with this one, just put it in your retainer agreement. Make it very clear to the client that you can have third-party payors, and then explain all that involves. A lawyer can represent an organization or its members, but not both, unless the interests of the organization and members are not adverse or potentially adverse. A lawyer and his or her firm cannot represent a client where any attorney in the firm has been affiliated with the case on behalf of another party while at different employment, even if the tainted attorney is not presently allowed to access the case facts or files of any party. In bankruptcy court, a debtor's attorney cannot be both a creditor of the estate and represent the debtor. It's a clear conflict. And then just note that disqualification of one member of a firm for a conflict of interest may disqualify the entire firm. If there's no screening mechanism you can put in place, the entire firm could be disqualified from representing that person. So again, talk to your client. If it's ethically acceptable to get informed consent, do it. And if there's any situation where it could look like representation would be improper, talk to your client. Again, speaking from experience, in one of my cases, I met with a wife and she wasn't sure whether her husband was going to file. She thought he was. Fine. So she retained my services. She gets served. I see opposing counsel as my uncle. He also does domestic relations in Omaha. So under the rules, there's no conflict. He's my uncle. But there's nothing that's going to be adverse to the parties or to the case. But I still told my client. I let her know over the phone and in writing, hey, opposing counsel's my uncle. This is not going to prejudice your case in any way. Asked for her consent, and we moved forward. And a good reason to do this is, again, you don't want it to come out months down the road and your client finds out that you're related to opposing counsel, and that appearance of impropriety causes them to question everything that's happened up until that point. So communicate. And that's one thing I do remember from professional responsibility here at the law college, communication. Just talk to your clients. Make sure they are just as informed as you are. Make sure that they feel comfortable giving you information, and keep those lines of communication open. All right, so moving on, lack of experience. And I know this is something that new attorneys question a lot. Are you experienced enough to take this case? Do you know enough to be dangerous? Sometimes that's all you need, but just know if what the client's telling you that he or she needs exceeds your experience, then it's okay to decline it. And again, that's a good time to have that referral sheet handy. Make those networking connections with your trusted advisors. Be able to support that client and say, I think it's in your best interest that you go see so-and-so at this firm to represent you. So with the lack of experience, just another thing to keep in mind that is always looming over our heads, you don't want a disciplinary complaint or a malpractice suit. So if it feels over your head, go to your managing partner or just decline representation. All right, so no meritorious claim. So again, after reviewing the facts, can you help through the legal system? And I heard the end of that last presentation, and sanctions are going to come up again here. So if you're filing claims that, there's no merit in law, there's no basis for that, you could be setting yourself up to get hit with sanctions. So there is section 3-503.1 of the Rules of Professional Conduct to be aware of. Rule 11 of the Federal Rules of Civil Procedure. That rule says that by signing a pleading or other papers, that attorney is certifying that the claims are warranted by existing law or a non-frivolous argument for extending, modifying, or reversing the existing law or establishing new law. And so this one, although this is a federal rule, it's still, there's similar state rules. And again, in my experience, I do have a case right now where I am trying to make new law. But what I'm arguing, it's not frivolous. It's a meritorious claim. It's before the Supreme Court right now. So again, that action, even though there's nothing in Nebraska law that provides for it, it's still meritorious. It's not frivolous. Statute of limitations is always something you need to consider. Is the client's potential case time barred? You need to be aware of those, be able to advise your client accordingly. So another thing that we kind of touched on, you really need to get to the heart of what does your client want and is it possible to get that for them. So if there's a case where this person is telling you how they've been wronged and so did it, well, but they don't know where that person is, how are you going to get them served? Of course, there are ways to do it by publication and all of that, but just things to think about. Can I actually help you within the confines of the law? What type of relief does the client want? And that's where you're going to have to educate the client on this is what I'm hearing happened. Here's how the law can remedy the situation or perhaps not. The next one's a big one. If monetary relief is requested, can the defendant pay it or does insurance coverage exist? So in this consideration, you have to think about if you're going to be spending your client's money to go after some monetary relief, but they're never going to see that benefit, is it worth their time and money? A practical example of this I had recently. It's always fun when you have pro se opposing parties. And this person in particular was filing frivolous motion after frivolous motion, causing me to go to court once a week. At one point, we had over 80 pages that the judge needed to read of his motions. And what I wanted to do was hit him with sanctions because I was spending so much of my client's money, so much of my time because I needed to read it, to do my job. And that's just not fair to her. So I wanted to file sanctions against him, or a motion for sanctions. But then you have to take a step back and ask, just because you can do it, should you do it? Well, I really wanted to do it as a lawyer, but then I thought, this person, this pro se person, doesn't have a lot of money. It's going to cost me money to draft a motion and file it. And even if I get the award for my client, is this person ever going to pay it? And after that consideration, I decided not to move forward with that. And instead, I just asked for attorney's fees at the hearing that I had to go to anyway, which turned out to be a good decision because my client did end up getting attorney's fees from the judge. And then it saved her that expense from me filing an additional motion on her behalf. Consider attorney's fees. So what is that prospective client looking at in terms of fees? We like to educate our clients and tell them divorces can run up to $25,000. You know, that's not an unlikely scenario. So we want to set them up for success. We want to make sure that they're well funded and that we can continue doing work on their behalf. So again, just be open with them about this is going to cost some money. And again, you're going to want to help everybody, but you need to be realistic. Can this client afford to pay? You can also consider if this client is expected to come into some money at the end of the litigation. In the domestic relations cases, you know, there will be a division of the marital estate. If there's some money there that could be put towards the attorney's fees, then that might weigh in favor of taking that case. And then, you know, that can go into other agreements you have with your client. So back to the accumulating facts. What we like to do at our firm is give all of our prospective clients a questionnaire ahead of time. And it's about 8 pages long. And what it is, it just goes through pretty much everything we need to draft a complaint for that person. So this person, it's a lot of background information. They go through it, they fill it out as best they can. So then when they come in for their 1-hour consultation, I have an outline of what's going on in that case. We ask them to come in a little bit early so I have time to review it, make my own notes, and then I'm able to talk with that person with as much information as they've provided for me. So that's the benefit of the client really getting a good hour's worth of legal advice, and you get to wrap your head around what can I do for this client. Additionally, if that client does move forward with your representation and retains you, you can have a complaint ready for them, you know, as soon as the next day if your calendar allows for it. Or your paralegal could do it pretty fast because we have all that information at our fingertips. Also, in accumulating the facts, it's good to just ask that prospective client to tell you their story. Some people will be more reluctant to tell you their story, and that's where you just have to have those client counseling skills, asking the questions, making them feel comfortable. Some other clients or prospective clients will talk for the entire hour and you leave feeling like you gave them no legal advice, but they had your ear for an hour. So again, open-ended questions are always great. When you're dealing with non-party witnesses, it's good to stay as non-biased as possible. Don't lead them. Just more like a direct exam. So you're asking those open-ended questions. You want to extract those facts from the witnesses instead of coaching them to say what's going to be helpful for your case. You also want to start getting the documentation that you need to present your case. So that means identifying where it is, obtaining it, knowing off the bat that whatever practice area you're in, you know you're going to need 3 years of tax returns. So ask them for it in the initial consultation. It might be good practice to have a list of items that you need that client to return once they retain you. So we have a checklist we give every prospective client, and we call it their homework. We tell them this is going to lower your legal fees if you're able to provide me your most recent pay stubs, your tax returns, your retirement statements, you know, all of those things that we know we're going to need. So why not just ask for it up front? They get it back to you, and it helps the process move much more smooth. You also want to see whether you need any releases or authorizations for obtaining confidential records. And then it's a good idea early on to identify whether you think you're going to need an expert. It's best practice to just get that identified as soon as possible because you know it's going to happen. So make that initial contact, give them an idea of what services you need from them, and keep in mind if you think this will go to trial, can this person be qualified as an expert? Okay, so the next piece of learning is is there another attorney involved with your client? So be clear. If your client is already represented, are they looking to fire their attorney and hire you, or are they looking for joint representation? So you just want to get clear from your client what their intention is there. Then when you're looking at whether it's practical for you or your firm to accept the case, I would highly suggest just talking with your managing partner or talking with senior counsel and see, you might really want to do this, but from a business aspect, is it practical for me to take it? And some of those questions you're going to ask, does your firm have the time to do the case within the client's reasonable expectations? Is there an upcoming court date? And does your calendar allow for you to do the necessary preparation? Do you think the matter will go to trial? Do you think it can be settled? Is there a distance consideration that you need to think about? And then again, the lawyer, the firm's experience or lack of experience should inform whether you should discourage acceptance or accept the case. And again, and I told you they're all interrelated, so this comes up again. Would the client's interest and or pocketbook be better served by someone else? That's where you want that referral sheet handy, and you can tell this prospective client, I personally know this referral. I consider him or her a trusted advisor. I know him or her personally, their quality of work. And just know when you refer other attorneys, and it's a great experience, that will reflect positively on you as well. So after all of that is said and done, then you need to look at either telling the client, yes, we've taken your case, or I'm sorry, we cannot accept your case at this time. So best practice, and put it in writing. Send them a disengagement letter if you're going to decline representation, or if you're going to accept it, put it in writing with the retainer agreement. That's what we like to do. In addition to that, it's a good idea to have a phone call with the person. Keep the lines of communication open. At our firm, we have a client services manager who does all the accounts. She's the one who's going to talk to this prospective client and say, here's your retainer fee. I'm going to go through this retainer agreement with you. What questions do you have? So that keeps the attorney's focus on the law while she gets to focus on the accounts and all of that. So in your materials, you should have some examples of disengagement letters, of a sample retainer agreement, and some other agreements when you begin that attorney-client relationship. And that is all I have for you. So if there are any questions, I'd be happy to answer them. No? All right. Thank you.
I have a quick question.
Yeah.
Why does that one client that you had represented the wife and her husband was pro se and was filing a lot of motions? How is he getting that information?
What information?
How do you know how to file all those motions?
I'm not going to say he followed the rules when he did it. He had some pretty hysterical names of the motions. And then when he didn't set them for hearing, the clerk set it for him because he didn't do that. And then he didn't show up. So the judge wanted to admonish him, but never got to hear that. Yes. Yes. In retrospect, very comical, but in the moment, not so much. Thank you. Okay, last but not least, we have Jodie, how do I say your last name?
Haferbier?
Haferbier, Jodie Haferbier McGill. She's going to talk about negotiations and settlements. Jodie is with McGill Law in Omaha, and she specializes in family law, collections, collaborative law, civil litigation, and landlord-tenant cases. She's a trained family law mediator and collaborative professional and is licensed in Nebraska and Iowa. She graduated from the Creighton University School of Law. Thank you, Jodie.
And I promise I will not go over. That's kind of the risk of going last, but I will go through this so that I do not go over and keep you guys here longer than you have to be. I've been practicing for 12 years. I started out in a insurance defense firm, and we also did plaintiff's work there. So I've experienced it on both sides of litigation. I've been in my own firm since 2011, and now I'm focusing more on collaborative law and mediation. So I'm going away from trial work. I still have some cases, but I'm no longer taking new litigation cases and focusing on negotiations and settlements. So that's why I'm here to talk to you about this today. During the time of my litigation, I've done family law, probate, including guardianships, special administrations, a small amount of criminal, some employment law, business formation, adoptions, and mediations. So trial skills are something that we are all taught in law school. It's something that we focus on a lot. We spend a lot of time increasing our skills to be able to do trials and conduct trials, but that is really a dying art. There's been a lot of research done lately about the decrease in trials, and I will say in my 12 years of experiencing that, I've seen it firsthand. I tried a lot more cases at the beginning of my career than I try now. A lot more cases get settled before we even walk into trial or even really get to the point where we're setting that trial date. There's some information up here. 2004, there was an Arizona study showed that approximately 97% of civil cases are settled or dismissed without a trial. 2011, a Florida study showed that less than 0.2% of civil cases went to trial, and that did not include probate, family court, or civil traffic infraction cases. U.S. Justice Department study showed that state courts in the nation's 75 largest counties, that there are fewer cases going to trial and juries are awarding less in damages. So not only are there less cases going to trial, but juries are awarding smaller verdicts, so people are less incentivized to go in front of those juries. In that study, it was down from 5.5% of all cases in the 1960s, which still is pretty low, but now we're down to 1%, and that's federal court. So it does correlate both state and federal court, but these numbers are getting less and less. There's some reasons for this decline. Like I said, juries are awarding less money, so that's not incentivizing people to go there. There's also a lot of judicially created obstacles to explain this, such as enhanced pleading rules, summary judgment motions, Daubert motions, class certification hearings, plea bargains, motion in limine practices. There's ADR, which has really taken off in the last 10 or so years, and that's what I'm kind of focusing on in my practice, but those options are now more available, and the consumer, the clients, they are more aware of these options, so they are now demanding that this ADR, these kind of practices, be utilized. There's actually, New York University School of Law has established a civil jury project to study the reasons for the decline in jury trials. So this is a real phenomenon. I couldn't find Nebraska statistics like this. I could find this in Iowa, which I think correlates a lot with what we do in Nebraska. But this is exclusively for jury trials to kind of explain or look at the numbers of the decrease. It took the first year that it looked at is 1995, and the most recent year is 2014. In 1995, there were 1,426 jury trials. In 2014, there was 815, and that is in district court in the whole state of Iowa. That includes civil cases, indicted criminal, and simple misdemeanors. Some observations about this study, if you were to look into it a little closer and kind of look at the data, is that there were 13 counties in Iowa that had absolutely no jury trials during that 2014 year. There were 61 counties that had 3 or fewer jury trials. So these judges and these attorneys who are presenting these jury trials really aren't getting a whole lot of practice on their skills. They're not doing them very often. They're having them infrequently, and they're not doing them nearly as what they used to do back in the 90s. Another interesting factor, if we look at this study, is that it shows there's been an increase in filings during this time in cases like divorce modification, domestic abuse, landlord-tenant, forcible entries, and adult mental health commitment petitions. So the types of cases that are being filed are also different and lend themselves not to go in front of a jury. Some of the pitfalls of going to litigation and actually having that trial are it's expensive. Obviously, we know that. That's kind of why some attorneys like to go to trial, because we get big billables. There's a lot of time to prepare for a trial, and then you're sitting in trial billing the whole time you're there. But not only is it expensive for the client to have an attorney prepare for and go to trial on their behalf, it's also emotionally expensive for them. They really have no idea how that trial is going to turn out. It's difficult for them to plan their future if they have their future involved. If it's an auto accident case and we're dealing with an insurance company, they're not going to be as emotionally invested in the outcome as if we're talking about a domestic relations case and we have parents fighting about the future of their children. If we have those kind of domestic cases, the emotional toll on these clients who go through trial is, I can't even explain how much it really wreaks havoc on these people in their lives. Risky. We've all probably had a case or know of a case where the facts are on your side, you think the witnesses are on your side. There's no way that you can really reasonably see you losing that case when you go into trial, and somehow the judge gets it wrong. I've certainly had a couple of those cases. I don't know if the judge wasn't paying attention, if they misheard the evidence, if they liked the other person better. But really, it's human error. We're dealing with other humans, and we don't know on that one day how our witness is going to project to that judge. We don't know what biases are going to be present for that judge or that jury. And really, it's a big risk to go into court. Public, this might be a situation where a client doesn't want everyone to know what's going on with their life. If it's in the courtroom, people can come in and see it. If you're there with your client, there might be other people at the courtroom. There might be press about it, which is probably not very likely, but it certainly is a possibility. Also, if you have a domestic relations case, in that order, you don't get to control what kind of facts go into that order. So it will talk about the value of the estate, the value of the debts. And a lot of people don't want anyone to be able to go look at that order and find out that kind of information. I wouldn't want that information part of public record and available for anyone about myself. So if we can devise a plan to go away from that, a lot of people can see the advantages of it. And then also time consuming. Again, kind of go back to the expense. Not only is it time consuming to sit in trial, but if we're going towards trial, we also have meetings with the attorneys and depositions and strategy meetings and things like that. They're taking time away from that client being able to go to work, maybe bill, and really make money. I've kind of touched on the family law matters. I think most judges would agree that more often than not, family matters should be settled without a trial. It's not always that we can always have that. Sometimes it just is inevitable we have to have a trial. But there's so much harm that can be done to children by going through that process that we really should counsel our clients on the risks of going to trial, especially in family law. As you all probably know, mediation is required in family law cases if parents don't have a parenting plan developed between them. That's a good start, I think, that they are forced to try to sit down and develop something outside of the court, but mediation doesn't always get them there. Mentioned that I do collaborative law, and that is a process by which the parties agree at the beginning that they're not going to litigate it. And what that does is it changes the whole dynamic of the case because people are no longer opposed to each other and fighting. They're trying to figure out how they can work with that other party to get a resolution. And they're not presenting evidence to a third party. They're the ones that are making all the decisions. And also in family law cases, there has to be some kind of resolution to the parenting time for the kids, child support, alimony, spousal support, and the division of marital estates. You will not get a, think of it, jury verdict or something, a defense verdict where it's over. There's got to be some kind of resolution to those things. So going to trial and leaving it all up to a third party is usually not the best way to go about it. So negotiation. I'm going to go through 5 different kind of steps or things to think about when we're doing negotiations. This is going to be very surface level. We're only here for 45 minutes. so you're not going to get deep into negotiation skills. That's obviously a deeper kind of learning thing that we don't have time to do today. But I'm going to try to give you things to think about before you go into these negotiations, and so that you're looking at it a little differently. And obviously a successful negotiation means that you've reached some kind of resolution. The first thing is to know your case, and we've heard that kind of over and over today, that you need to be prepared. And that, again, for negotiations, that's something else that you need to do. A party should obtain as much relevant information about the case right at the beginning. I would suggest not waiting until you get to that discovery phase where you're getting the questions from the opposing counsel to ask your client, but already kind of have an understanding of what those answers are going to be. If it's a car accident, go out to the site before that discovery phase even really gets going and understand it. Kind of delve in deeper onto those substantive things. And then I'll go through the kind of three things, but have a level of understanding of substantive facts, motivation factors, and the law on your side. You want to do this again as soon as you can, as soon as you get a case. So for substantive knowledge, that's kind of the who, what, where, when of the dispute. And so again, before you even get to discovery, interview the witnesses, talk to the other people who might be involved, start collecting the data. I always look for both my client and opposing party, if they're an individual or if they're a company, on the internet. I always try to look for them on social media and see what's out there. I always also do a justice search. That's something we have access to, and it's amazing what you find in people's records that if you don't, even if you ask them, they might not tell you the whole truth, but that certainly can paint a picture for you of who you're dealing with, both your client and the opposing party, by just taking those few steps. You want to know the motivational factors of a case? Oh, audio might not work. Well, I was going to try to make this somewhat entertaining, but I don't know how to make audio work on this. Can you do audio on this? So we talk about motivations. Know really what your client wants out of this case and what opposing party wants out of this case. And these are things people have talked about today as well. But you need to find out, is this person really want to file a lawsuit because they really just want the other party to apologize? You know, if that's really what they want, you can probably get that for them, and it'll come at a much less cost if you figured that out beforehand. I typically ask clients, what's the best case scenario? What would be the outcome of this case? And you get a lot of information from that person by asking that kind of open-ended question, because they might tell you what they really want. And we know in the judicial system, if we go in front of a judge, really what we can get for our clients money. There we go.
Is this the opening scene?
No, yeah.
It's the same thing.
Shit, more the kids are.
Do not talk about me as a mother. I'm so sick to death of you talking about me as a mother and what I've done wrong.
Firehouse.
Do not talk about that. I am sick of you keeping me from being a good mother. 7 years I've been a good mother. Just remember when you're right now. Just remember. I'll turn a back. Don't you fucking talk about me as a mother. I hate you.
Yeah. Why don't you just kiss my left nut?
I told you this was a bad idea.
You know what, Ken? The bad idea would be like a client walk out of here today and drag this thing out from out of here, wasting more time and wasting more money. The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress. We settled the deal with the cars. Let's see, that takes us to frequent flyer miles. We're flying.
I want the.
You know what we're going to do? We're going to split them right down to how that be, Mr. Koenig.
It would be not good at all. I earned those miles.
Yeah, you earned them flying to Denver to meet your order.
Oh,
She's She's not afraid to express herself sexually, if that's what she needs.
She's a stripper, for God's sake.
She is not.
Her name is Chastity. She is white trash. Same as you. Hillbilly.
That's it. Go come and tell us for me.
You shut your mouth when you're talking to me.
Boy, this is getting confusing. You didn't always hate each other. There had to be some nice moments during your courtship, maybe? Or the wedding?
The wedding had to be fun.
You ever decoration, families coming together? That's a nice moment. What'd you have to eat?
Crab cakes.
Are you kidding me? Crab cakes? I think I have a good time eating crab cakes. I love them.
You know a band? You have a band? Good or bad?
Who gives a shit? The great band is a bad band. It's like pizza, baby. It's going to matter. There's music in the air.
Shout.
Shout out. Come up and shout now. It's a good time, you know what I mean? Rub up against each other. Just a couple of kids like the fuck trying to make it honest. I get it. Guys, the real enemy here is the institution of marriage. It's not realistic. It's crazy. Don't do this for the other person. It's about saying yes to yourself and saying yes to your future. And have some opportunities for yourself. I'm sure you'd love to be free. Maybe go out and meet some Latin guy that can dance, grind up on you, make it feel dangerous, but also safe. And how about you? Don't you want to get inside Chastity without having to wonder if everyone's going to find out?
That'd be sweet.
Wouldn't that be nice? Have some Latin guy sweating all over you, talking to you in languages you don't understand, eating you, wanting you, taking you.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on. Get out there and get some strange ass.
Could you get her a glass of water so she'd take that? Hey, that's great. That glass looks half full to me.
Well, now that you mention it, it is half full.
You can have the last.
Yeah, sweet. You take the miles.
Great, great. Let's sign the paperwork and we are done.
This is just an answer. You guys want to throw a couple miles at us? We'll get a couple. Big thing is that we're all moving on. You're just not talking anymore.
Okay, obviously a humorous way to look at that, but really they were getting at more than letting these people fight. They were getting them to think about other motivational factors as to how they can move past this, because having them rehash their bad deeds wasn't getting them anywhere. So that's kind of a good example of changing the pitch and trying to figure out what is actually motivating these people. And Lindsay and Staci both kind of discussed expectations. That's, again, back to the whole understanding of what your client really wants out of this. And there might be something there that you can get for your client that's other than money that is easy to come by. And the other factor of knowing your case is know the law. You should probably do some bit of research on nearly every one of your cases, whether that's just checking what you think you already know, making sure that it's current, having the statute of limitations known right at the beginning so you don't blow that. Look at things like attorney's fees. Is there a statute that allows you attorney's fees? Is it a must award attorney's fees or a may? And that will definitely play into your bargaining strategy if you know these things beginning at the onset. No case law that's good for your case law that's bad for your case. Is that case law that's bad for your case? Can it be distinguished? Just doing all these things at the beginning. These are things we all know to do, but to do them at the beginning is what's really going to help you try to formulate a strategy to settle this case earlier. So when you talk about developing a strategy and determining an objective, I urge you to actually think about it. Most people go into negotiations and they don't have an actual strategy except for to try to settle the case. But if you're the one initiating this, think about timing. Do you want to do it right at the beginning when you're the one that's put all this effort into understanding the case early? Do you want to do it before discovery? Do you want to take a couple depositions first? All of those should be considerations in how you want to develop your strategy for negotiation. Do you want to try to have a settlement conference before you take depositions? Do you want to get a mediator involved? And when do you want to do that? Just think about all those things and what to develop your strategy instead of just letting it play out. You should develop objectives based on your motivational factors of your client. Try to figure out the motivational factors of the opposing party, and that again should help play into how your strategy is. And again, I would encourage you to think outside of the box when you're having this kind of thinking strategy ideas. I'll tell you an example of a case where I thought outside the box and it got settled was I had a surcharge case. It was a guardianship case where the prior guardian was stealing her mother's money. And I knew that if we got a judgment for this daughter to return all the money to her mother would no longer be eligible for benefits, and she probably would never pay it back. So trying to think outside of the box, we reached an agreement whereby she was going to purchase a funeral insurance plan for her mom and pay attorney's fees. And what that enabled the court to do was say that she was wrong, she shouldn't have done this. I think she got put on the central registry, but her mom then was cared for in the future. The amount of money she would have given to her would have gone away to social services and the care that her mom needed. So this was a good option to actually get a settlement without, prior to going to trial and getting an award that might have actually been harmful for the client. When you're developing your strategy, you need to make sure that you're keeping your perspective. Avoid groupthink, which would be the practice of thinking or making decisions as a group in a way that discourages creativity and individual responsibility. Again, try to think outside the box and not go along just with what everyone else is saying. Don't tell your client what he or she wants to hear. I think a lot of attorneys kind of fall into that because it's easy. It's easier to tell someone what they want to hear instead of what you really think about a case. So if a client has unreasonable expectations, tell them that. Don't let them continue on with the case with these unreasonable expectations that will never be met, because at the end, your client's not going to be satisfied. They're not going to think that you did a good job because they have these unreasonable expectations. And assumptions. Try to find out the facts before making assumptions. Don't walk into something and think the employer is always the bad guy because you've always been on the other side. You need to learn the facts, and maybe this is a misunderstanding, or the facts can play it out, and so you understand both sides of the position. And again, keep an open mind so that you have the ability to think outside of your perspective. You obviously want to be persuasive when you are working on reaching a settlement. You want to, if it's a written statement, you want to make sure that you're using law and support your position. That goes for a mediation statement. That's your first kind of contact with that mediator. Some people don't take that contact as they should and make it very persuasive, but that should always be in a settlement letter. You should say, we're asking for this much money, and tell them why. And I see that a lot, that we get a settlement letter and there's assumptions or statements made throughout and they're not supported. This person violated the contract, and then they move on. Well, tell me why you're saying they violated the contract. Point to the part of the contract and give me some support, because that's helpful for the clients too. And that can help you tease out whether or not this case should be settled sooner or actually go to trial. Attempt to keep the other side from becoming defensive. Sometimes when we want something so bad, we push really hard. And if we're advocating too zealously for our client, we can put the opposing party or opposing attorney on the defense, and then they're not going to be willing to give up anything because they're feeling protective, or that they need to make sure that they're not giving anything up. A good strategy is always to lead the opposing side where you want them to go. We all know personalities that they won't agree to anything unless it's their idea. So that can be done by rephrasing, by just changing the language, by not offering what you really want, but letting the other side get there. There's different strategies of doing that, but if be cognitive of having that strategy, a lot of times you can get that person where you want them to go. Don't be afraid to use silence. If you get a written offer for settlement and you think it's ridiculous, you don't have to sit down and write a nastygram back telling that person how ridiculous you think it was. You can just ignore it. And sometimes that will garner another offer that might be better. That happens in person a lot more than in writing. But if you're sitting across the table from someone and they're giving you offers or making demands that are unreasonable, don't feel obligated to make something back. Silence can be a factor. And always tie your persuasion back to the other side's motivational factors. You should have known these, you should have figured these out at the beginning, so you want to make sure that you're always looking at those when you're trying to figure out how to be persuasive.
In the interest of putting this whole thing to rest, PG&E is willing to offer the Jensens $250,000 for their home.
$250,000.
In terms of land value out in Hinckley, Mr. Mason, we feel that's a more than fair price.
How about in terms of medical expenses? $250,000 isn't gonna come close to what this family's gonna have to spend on doctors.
I understand they have bad on the luck, health-wise, and they have my sympathies. But that's not PG&E's fault.
Okay, right? Look at these readings. PG&E's own technicians document toxic levels of hexavalent chromium in those wells on numerous occasions. Everything the Jensens have had is proven reaction to exposure to hexavalent chromium. They have had. They have passed.
Breast cysts, uterine cancer, Hodgkin's disease, immune deficiencies, asthma, chronic
A
belly.
million things could have caused those problems. Poor diet, bad genes, irresponsible lifestyle. Our offer is final, and it's more than fair.
Wait a minute. I just thought we were negotiating here.
$250,000 is all I'm authorized to offer.
I'll present your offer to my clients. I doubt that.
Mr. Minstrey, before you go off on some crusade, you might want to remember who it is you're dealing with here. PG&E is a $28 billion corporation.
$28 billion? I didn't know it was that much. Wow! 28 billion! Holy cow!
Okay, so in that example, Aaron Brockovich, and I had to look up the attorney's name because no one remembers the attorney's name, just Aaron Brockovich, Mr. Masery, I think is how you say it. They came in with the facts, the documentation, they had worked up the case, they knew, they had made a personal connection with these people, they knew exactly what they were doing, what they were asking for. The other guy came in, he made one offer, he had no room in his negotiations, there was no negotiation. He insulted the clients, he just came in and then he tried to threaten the other side by saying how large his client was, which obviously kind of had the reverse effect, and plaintiffs were excited by that fact. So we're talking about bargaining. You always want to use your leverage. This is a quote on here: if there's one secret of success, it lies in the ability to get the other person's point of view and see things from that person's angle as well as from our own. Try to look at things from both sides. Try to understand their motivations, where they're at, what they want out of the case, where they're going. If you have a positional advantage, you want to make sure that you're aware of it and use it as much as you can. I don't know if you guys watched Game of Thrones, but a great example of that, if you watched last week's episode, I guess a bit of a spoiler, but Jon Snow came in to Daenerys Stormborn, what's her name? Daenerys Targaryen, sorry. Okay. And he wanted to mine the dragon glass. She didn't know what dragon glass was. She didn't know that she had possession of it. So at the end of the exchange, she told him, go ahead, have it, because that might change the whole dynamics of the relationship, and she might get what she wants from him later for giving him something that she didn't even know she had. So that's something that she was able to give him, had no value to her, but it will change the dynamic of the relationship and the negotiations for giving that something up. If you're going to give up something without getting something in return, then have that be part of your strategy. But think of that. Think of these things before you go into any kind of negotiations. If you want to try to get something for offering something up, then think about that beforehand and have that be built in. Also, just having a holdback, a closer, whether that's a fact or something, a bargaining chip, don't put it all out on the table, because then you're going to lose your ability to negotiate and find a middle ground. When you're involved in negotiations, always pay attention. You want to make sure that you're framing the issues about what you're giving, not what you're not giving. If someone is making a demand and there's a list of things and there's things on that list that you think your client says absolutely no way, are we going to even talk about those issues, that those are non-negotiable, I'm not giving them that, then don't talk about them. Don't say, no, I'm not giving you that. Leave them off the list and just present them with the positives of what you are willing to offer. Analyze the biases that are coming into the negotiation room or that are on the other side. You should have already done your kind of ground research and found out this person's social media posts. Maybe they've got criminal background, things to try to understand this person a little better, and that should be utilized in your strategy and how you negotiate with them. Watch anchors and where they are set. This is especially true for mediation. If you come into a mediation and out of the gates, someone makes a ridiculous demand, if they're going to try to come later and say, look how much room we've made. You know, we started at 1 million and now we're down to 500,000, and that's their anchor. And the other started at 0, and we're using those as anchors to show how much we've gone when really this case is only worth 500,000. Those aren't true anchors. And think about that when they're being framed about how far a client has moved on their position. If we're using anchors that are not good anchors, then it should be discussed. They should be thrown out. We shouldn't be talking about coming at 0 if we knew that this client was always going to end up paying something. We also shouldn't be talking about $1 million as the initial offer or demand if this was never going to be $1 million case. And then the last thing on there is don't gloat. If you get something, don't make a big deal out of it and make the other side be on the defense and feel bad about giving you whatever you've asked for and gotten. If you are able to reach a settlement and you think you're there, you're done, always encourage you to troubleshoot. That's part of your job when you're working on settlements, is to try to be devil's advocate and think about how this might have holes. What happens if someone doesn't follow through with their end of the bargain? And before you leave, if you're in a physical presence with that other party in a mediation or some kind of settlement conference, take time out, think about it, talk it through with your client, and you might be able to figure out some holes that you've left open. Because if you leave that day and you think you have an agreement, but you didn't talk about some of the minor issues, you might not really have an agreement. So make sure you're going through that and being devil's advocate before the negotiations are over, and you're really testing things to make sure that you've covered all your bases. I always suggest being the one to offer to draft the settlement, because that kind of gives you the last say in things. Your client will have to pay you for that, but you're the one that's going to be writing it, and you definitely have an advantage to being that person instead of just reviewing it on the other end and looking for things that you don't like. Again, make sure the details are spelled out significantly so everyone understands if there's payments going to be made. We understand by when the payments have to be made. We understand that they have to be by certified funds, or they have to be an automatic deposit or something. We have worked through all those details so we understand, and everyone's on the same page. Everyone has the same understanding of how it's going to happen moving forward. Make sure there's a full release so that if you've settled this, that person's not going to come back, the opposing party's not going to come back later and ask for something else or file a different claim looking for something else that could have been captured in this. And that's true for most civil litigation cases. If this is an auto accident, we would be asking this plaintiff to waive any right for anything, known or unknown, against this insurance company for this auto accident. But that is expanded beyond just auto accidents. We want to try to tackle and clear as many things out with that release as we can. Again, look at the situation from all angles and try to remain in control of this negotiation so that you have the final say and you've figured everything out. Throughout the whole process of preparing for trial or having a case that's going to trial or even after trial, there's always chances for settlement. Even if you have gone through a trial, you can still offer to settle that case. I had a case back when I was at the insurance defense firm, and we were obligated to inform the insurance company very routinely where we were at with the case. So I know that we told them we have trial starting, and they were usually pretty involved in what we were doing. And we'd give them trial reports after every day telling them how trial went. We had one day of trial. We got a jury in the box. We thought things were going really well. And someone at the insurance company, our client, forgot to send it up chain that we were in trial. So apparently that happened. The next morning, our client called us and said, you have to settle that case. We didn't know you were in trial. You have to settle it. So we had been in trial for a whole day, and they were more willing to pay us to settle that case than to go through with trial, which we had to kind of swallow our pride because we thought that first day of trial went really great. You know, that voir dire was really good. Our opening statement was really good. And now we're coming to the other side and suggesting that we settle. Obviously, it didn't appear as though we thought it really went that well, but there is always a chance to settle. I've gone through a jury trial, had a great result. It was probably should have been a $50,000 case. We got a $100,000 verdict from the jury, but then we have to collect it. Once you get that verdict, that's a whole nother ballgame trying to collect on that verdict. So after a lot of show causes, and the opposing party actually spent some time in jail for not appearing on show causes, and they were threatening to file bankruptcy. We consulted with a bankruptcy attorney, kind of showed them what was going on. It was a business, and we ended up settling it for a lot less. Again, you kind of have to swallow your pride because it feels good to get this big jury verdict, but if you can't get money into your client's hands, it doesn't really do you or them any good. So there is chances for settlement all throughout, even if you've had a trial. Constantly reevaluate the risks of not settling. If you've attempted mediation and you're back on the litigation track, think about it again. Talk to your client again. Keep that dialogue open because you need to understand whether or not that client is able to continue to pay you. You need to understand if there's something going on in their lives that has changed the dynamic of the case. You need to understand if there's some other kind of motivational factors that is encouraging them to get this over with. And so just continue that evaluation throughout the whole process. Maybe you find out that opposing party could really use some money right now, and if you're on the side who is making the offers, that might be a great opportunity for you to revisit the negotiations if you find out that information. Again, reevaluate your strategy throughout the whole case. That kind of goes back with the motivational factors, but keep checking back in with your strategy and seeing how things have been met. Maybe you need to adjust, maybe you've learned new facts, but continue to do that throughout the whole process. Negotiation skills, just like trial skills or any other skills, are skills that should be practiced. We could sit and do and practice them, but I hate doing that, and I think most attorneys do as well. But there are things that we need to practice in order to become good at them. So I would encourage you to think about that in your day-to-day life if you're trying to buy a house or do whatever. Sometimes it is easier just to pay that amount or buy it for that price. But if we want to work on our skills to become good negotiators, do it for yourself first, and then you'll be able to represent your clients more effectively when you come to representing them in their interests. Any questions? Okay, that's all I had. Thank you.